Senator Surabel. Senator McClellan. Senator Morrissey. Senator Stanley. Senator McDougal. And Senator Deeds. You have a quorum, Mr. Chairman.
Okay. If anybody needs to leave with proxies, please do that. And we've got several bills. We've got several expungement bills. We've got a marijuana bill. They're all very serious. I'd like to do the expungement bills first. And I guess the idea would be to present them and then for the committee to ask questions as we go along and figure out what sort of policy decisions we want to make. Morrissey Bill 1283 and the Lucas Bill 1372 look to be very close. I think one's about 5 lines longer than the other. The staff bill is a piece of bills that are covered, a piece of what's covered in all 3 bills. The Surville bill is closer to what we did this past summer, but it's not. Senator Lucas and Senator Morrissey, if you want to present your bills first, that's all right.
Mr. Chairman. And as Senator Lucas is the chair, we need to get her out of here. D-Steph's bill is very short. We could probably knock that out second. I think we'll probably be most efficient and get him out of here.
Senator D-Steph, you've got 1294. Do you want to?
Sir, I'm happy to come after.
I was suggesting Lucas go first and D-Steph go second.
No, your chair is. Oh, okay. No, but that's on camera. Okay, got it. All right, I just need 1 second to bring it up.
Okay, your bill is Senate Bill 1294, and it just deals with the fee for a petition on for expungement. I think
$25 fee with the clerks.
and that would be a non-refundable fee.
Yes, sir, that's correct.
Okay. Now, at current law, the fee is refundable in certain circumstances. Is that correct?
Yes, sir, that's correct. In the current law, it's refundable if the individual is expunged. The problem is to track the individual down, to cut the check, to do the whole thing is more expensive than $25. So what we're recommending here is just no fee because it costs more to administer, or make it $25 and non-refundable. So $25 non-refundable is a great way to do it. It helps cover a little bit of the costs, or no fee and make it free.
Okay, does anybody have any questions of Senator D-Steph?
Mr. Chairman, I have no questions, but I have
Senator Surville.
an idea. Mr. Chairman, I agree with Senator D-Steph's what's motivating his bill, in that collecting the fee and then paying it back is kind of silly, and I can't remember why or when we did that, but we did it about 4 years ago. The approach that's taken in the bill that I think is going to be the vehicle is that the fee is accepted, collected, and then paid into an expungement fee fund. And so if Senator D-Steph would like to have a bill that lives on, he could perhaps conform the fee in his bill to the fee in the bill that I think we're going to pass. And I don't know if Mr. Quagliato would say there's any other changes that would need to be made to his bill to conform it, but I think that would probably be the appropriate course of action, if Senator D-Steph wants to be part of that.
Mr. Chairman, I've not read the entire Surville bill yet, and I'm just trying to hit one small problem, which is costing our clerks a ton of money.
I get it. I think the question is whether or not you want a separate bill, or you're all right being part of something else.
Mr. Chairman, I'd rather have this as a separate bill and let them meet up, because normally what happens if we have 2 bills go through, when it goes to the governor's office, they make them the same anyway when we do the code change. I'd rather not have this get drugged down by all the other stuff in another bill that I've not had a chance to truly read and dissect.
Are there members of the public that have signed up to speak on Senator D-Steff's bill?
If you'd like to speak in support of the bill, please raise your hand.
Expungement.
No, nobody. Is anybody opposed to the bill?
If so, please raise your hand. I see one hand, Mr. Chair.
Okay.
Lauren Penn, please unmute yourself.
Okay. Well, what's the committee's pleasure on this bill?
Mr. Chairman, I'm not sure Senator DeSteph understood what I was saying. I think Charles could tell us whether or not there are any amendments necessary to Senator DeSteff's bill to conform it to what we're about to do, or whether it can live alone. I think it's inconsistent with what we're trying to do right now.
Mr. Chairman, Charles here. And to Senator Strovel's point, if Senate Bill 1339 to move forward, which, as Senator Strovel says, takes the fee that's collected and puts it in an expungement fee. If Senator DeSteff's bill was to exist as is, it would essentially frustrate that purpose because he'd only be collecting $25. Never, I don't want to say never, but would frustrate the purpose of collecting the fee to fund the expungement fee petition for indigent defendants because you would never have enough money. So it is possible to conform Senator DeSteff's bill to the provisions of Senator Servel's bill, where it is collected and then deposited into the expungement fee, which is what I believe Senator Servel is suggesting. I just don't know if Senator DeSteff wants to go along with that plan or if he wants to have his bill exist as is and have the committee.
Senator DeSteph can certainly speak for himself, but I think what you're trying to do is solve a problem with the clerks.
Yes, Mr. Chairman, that's correct. And as happens here, when certain bills go to the other body, we run into challenges where everything gets changed or they just kill the bill. This hits one small problem that our clerks are having now, that it costs them more money to refund a $25 check.
Right.
It's costing them in the hundreds of dollars if they can actually find the individuals. And I'm just trying to solve that one specific problem.
And I think what Senator Servel's talking about, at least with his bill, you're going to have a regular fee that's paid into a fund to fund the indigent defendants or indigent folks who are trying to go through the expungement process.
Understood completely, and I believe that fee is, I've not studied his bill completely, but I believe that fee was $100.
Okay, well, what's the committee's pleasure on Senator DeSteff's bill?
Mr. Chairman.
Senator Servel.
Thanks. It sounds to me like Senator DeSteff wants to push a bill that's inconsistent with 1339, so I would move that we recommend PBI's bill in light of that, but you can always reconsider that at full committee if he changes his mind.
Okay, is there a second for that motion? Senator Morrissey.
I said Senator DeSteff could reconsider that by the time we get to full committee, perhaps. This is a recommendation from the subcommittee. It's not the actual action.
Is there a second for Senator Servel's motion?
Senator Edwards seconds.
There's a motion and a second. Is there further discussion or other motions? Senator DeSteff, you want to wrap it up?
Mr. Chairman, the only concern I have is I've seen great ideas and great bills get killed on the other side. Yep. And I don't want to have a good idea killed on the other side based on, we're still going to have a problem where the clerks are still spending hundreds of dollars trying to refund $25 if Senator Servel's bill does not make it through the other side, or if, pray tell, the governor were to veto it. I'm just trying to solve a little problem once at a time, and I'd rather not have it rolled in to something that could be used as a political football later.
And I understand that. I guess the question we've got to decide is whether we want to take inconsistent positions, whether we want one position to come out of this subcommittee or whether we choose another path. You've got a motion and a second. Is there any further discussion? If not, please take roll.
Senator Servel. Aye. Senator McClellan. Aye. Senator Morrissey. Aye. Senator Stanley. Senator McDougall. Senator Edwards by proxy. Aye. Mr. Chairman.
Aye.
5-1.
Thank you, Senator.
Mr. Chairman, members of the committee, thank you.
Okay, we've got three other expungement bills. The marijuana bill is a 13,000 line bill, and I don't want to shortchange anything, but the expungement bills are close to things we've seen before. The marijuana bill is something completely different, so that's going to take the majority of the morning. So 1283 from Morrissey, 1339 from Serval, 1372 from Lucas. Senator Lucas.
Thank you, Mr. Chairman. We had some technical issues over on the other side, so I apologize for being a few minutes late. Mr. Chairman, members of the committee, this bill was endorsed by the Crime Commission.
Senator Serval.
Mr. Quagliato told me that Senator Lucas has a substitute. We might want to get that in front of us first.
Yes. So moved, Mr. Chairman.
Okay, we've got a motion and a second for a substitute. Is that up on LIS, or do we have hard copies, or?
Mr. Chairman, that is up on LIS now. The substitute or changes recommended by the Crime Commission, they're mostly technical changes that were addressed, and I believe the Crime Commission is somewhere in the queue, so they could probably speak to the changes if there's any questions.
Okay, well, let's get the substitute in front of us. It's been moved and seconded. All in favor of adopting the substitute, say aye.
Aye.
Any opposed? Okay, the substitute's before you now.
Thank you, Mr. Chairman. Can you hear me well? Because I'd rather keep my mask on.
Yeah, we can hear you.
I have an answer for that. Is there something else I can help with?
This bill was endorsed by the Crime Commission, Mr. Chairman and members of the committee. The bill creates a new chapter entitled 19.2 of the code to automatically expunge certain convictions and charges that did not result in a conviction from a person's criminal record. The bill also directs the Virginia State Police, the Office of the Executive Secretary, and the Clerk of the Fairfax County Circuit Court to develop an automatic system to expunge charges and convictions. Automatic expungements mean restrict dissemination of criminal history record information and prohibit dissemination of court records except as authorized by a court order. The bill establishes processes to automatically expunge: 1, felony and misdemeanor convictions, including deferred and dismissed offenses, both retroactively and moving forward. Non-convictions moving forward, including charges based on mistaken identity or false identification information, false identifying information, and certain non-conviction retroactively. A criminal conviction or an offense that was deferred and dismissed will be automatically expunged after 8 years have passed, and the person has not been convicted of any CCRE reportable crimes in Virginia, and the person has not been convicted of a crime in another state. Criminal charges that do not result in convictions will be automatically expunged at the time the case is finalized, unless for some reason or reasons exist for not automatically expunging the charges. The bill requires that third parties who collect and disseminate criminal records must delete records that have been expunged or face civil liability and enforcement actions by the Attorney General. The bill also provides liability protections to employees who hire individuals with expunged criminal records. Automatically expunged records will remain available for specific purposes such as background checks for firearm transactions, background checks for employment as law enforcement officers, court clerks, magistrates, or judges, and employments with an emergency medical services agency, the Department of Forensic Science, or where required by federal or state law. Compliance with Federal Motor Carrier Safety Administration regulations by the Department of Motor Vehicles and medical examiners. Criminal investigations involving DNA or fingerprints, collections of restitution, fines, and court costs, preservations of existing case law, research conducted by the Criminal Sentencing Commission, providing exculpatory information in criminal proceedings, and to the individual whose charge or conviction was expunged. When an offense is automatically expunged, the person charged or convicted can deny that the charge or conviction occurred, except when applying for employment as a law enforcement officer or when required for employment under federal or state law. The bill prohibits that the state and local governments, private employers, educational institutions, and housing sales rental agencies from inquiring about an automatically expunged charge or conviction, except in law enforcement hiring and when required for employment under federal or state law. The bill also requires any charge or conviction on a person's criminal record to be removed if it was not required to be reported to the Central Criminal Records Exchange. Allows only CCRE reportable offenses to be included on a person's criminal record. Requires magistrates and law enforcement officers to note the corresponding Virginia Code section on a warrant or summons when issuing a charge for a local ordinance violation, and includes delaying implementation dates and reporting requirements. Mr. Chairman, members of the committee, based on feedback from stakeholders, the following provisions have been added to this bill since it passed the House during the special session. Third-party background checks require third-party background check companies to delete automatically expunged criminal records or face civil liability. Permission to disclose automatically expunged records to third-party background check companies so that the records can be deleted. Employee immunity. It provides protection for employers who hire individuals with automatically expunged criminal records. Language which specifies that fines charged under a county, city, or town ordinance will be paid to the locality. It authorization for the Department of Motor Vehicles to delay expunging any of their records that are required to be maintained under federal law. This is necessary in order to ensure that none of Virginia's federal highway funding is put at risk. Authorization to introduce changes, charges, or convictions that have been automatically expunged for impeachment purposes if the probative value outweighs the prejudicial effort and written notice is provided to the adverse party. Permission to disclose automatically expunged records containing impeachment evidence. Language that requires the state police to transmit the first list of individuals and offenses eligible for automatic expungement in the court within 3 months of the law taking effect. Language that requires the Department of Criminal Justice Services to develop regulations governing the disposition of automatically expunged record. And Mr. Chairman, that speaks to the substitute.
Let me ask you, Senator Lucas, the part you talked about, the third-party liability, has that been added to the bill since it was introduced?
During the special session, but Mr. Chairman?
Is that new in the substitute?
That is my understanding, but I have the administration here standing by to speak to that issue specifically, Mr. Chairman.
Let me ask you, are there, what offenses are not subject to expungement? Does this consider that all offenses?
Can I address that, Mr. Chairman?
Senator Morrissey?
Thank you. Excuse me, if I may, Senator Lucas. That's the biggest difference between my bill and Senator Lucas. My bill expunges all misdemeanors. I made a matrix of misdemeanors that are not included in Senator Lucas's bill. Hers eliminates or expunges many misdemeanors, but there is a complete basket of misdemeanors that are not expunged under Senator Lucas's.
What about felonies?
Senator Lucas, what does your bill do with respect to felonies?
Let me scroll back down.
Mine has certain felonies.
Yes.
I'm prepared to go over all of mine.
Yes, not all, Mr. Chairman.
Mr. Chairman.
If I could just finish one.
Senator Morrissey still got the floor.
I'm going to give this list to everybody, but things as minor as trespassing by hunters using dogs.
Joe, they can't hear you online. Make sure your mic's on.
Sorry. Some things as minor as trespassing by hunters using dogs, harassment by computer, encryption used in criminal activity, boarding or riding transportation district trains, diverting water lines, unlawful use or injury to telephone and telegraph lines, illegal possession of gambling devices, tattooing of body, piercing of minors, obstructing free passage of others. I can go on and on.
Let me ask you, Senator
They are
Morrissey.
not included.
Senator,
Those are not in her bill.
okay, your bill was close to Senator Lucas's when it was introduced. You haven't made the changes she has in the substitute, is that correct?
My bill, I'll try to be succinct in one sentence. My bill is identical to Senator Lucas, except for my bill includes all misdemeanors, and also it differs with regard to, I believe, I have a $20 million budget amendment to pay for my process. What is, I'm not sure what Senator Lucas is.
Mr. Chairman, the governor has put money in the budget for this bill. I don't have that exact number right here with me, but the governor's budget does include the money, the funding for my bill.
But the main distinction, I was trying to figure the main distinction between the Lucas bill and the Morrissey bill has to do with the offenses covered by...
That is correct. Those offenses that were listed by Senator Morrissey.
Okay, what I'd like to do, if all the patrons will agree, because Senator Servell, you're in this discussion as well, I'd like to hear about all of these bills. I'd like to hear public comment, and I want to do like 5 minutes aside, and I just want you to, when we get to the public comment, just identify yourself. If you're with a group, identify your group and tell us which bill you're for, which bill you're against. But we haven't gotten to that point yet, obviously. But Senator Morrissey and Senator Lucas both have automatic expungement bills after a period of time. I guess, Senator Morrissey, you've got the same 8-year period of time in your bill?
I do.
Okay.
Mr. Chairman, this is Charles here. Senator Morrissey's bill is the Crime Commission expungement bill that was last considered by the body in the special session. And the only difference between his bill and the special session automatic expungement bill is Senator Morrissey's bill includes all misdemeanors. So to the extent that his bill would need to be made consistent with Senator Lucas's bill, it would also need to adopt all the amendments that Senator Lucas has made in her substitute, which would make the two bills identical, except for Senator Morrissey's bill covers all misdemeanors. Those are the two different. That's the difference between the two bills.
Okay,
Mr. Chairman.
Charles, the difference in the substitute is primarily the third-party liability piece,
That's correct.
Chairman?
and is that close to the Servell bill?
No.
No, it's not.
It is different than the Servell bill. The Servell bill does address third-party liability, but does so in a different manner.
Okay.
Mr. Chairman?
Senator Servell.
I guess also a question for Charles. I keep hearing the Lucas bill and the special session bill referred to as a crime commission bill. I'm on the crime commission, and my understanding of those bills that they are different from the bills the crime commission voted on and approved. My recollection of the crime commission bill was it included class 4 felonies, including involuntary manslaughter and arson and some other things. And the crime commission also did not have any type of civil immunity for employers in their bill. And so there's been many changes made to the so-called crime commission bill that people are now calling it. Is that right?
That is probably accurate. Yes, Mr. Chair.
Charles, if I can ask you about the employer liability piece that's in the bill. It was not in a bill this summer, and so it's not in the Morrissey bill. Is that correct?
That is correct, Mr. Chair.
Okay. Senator Lucas, under that bill, if the employer has personal knowledge of an offense, even though it's been expunged, and hires an employee, the employer would have no liability for the employee's actions, even if they are consistent with what the employee was convicted of?
Mr. Chairman, that is exactly the way the bill reads.
Okay.
With the amendment.
Okay. Are there any additional questions of Senator Lucas? Okay, so I'd like before we get public comment, I'd really like to have all the bills.
Sure, I'll step aside for Senator Morrissey.
Okay, Senator Morrissey, do you want to?
Can I do it from here, Mr. Chairman?
You sure can. Yes, sir.
I think during the past colloquy, I established some of the differences. And I don't believe, since my bill includes all misdemeanors, there is no carve-out. I will present to you either now, I have a list, Mr. Chairman, or afterwards, a lengthy list of misdemeanors that are not included in Senator Lucas's bill. I see absolutely no reason why we wouldn't include all of these misdemeanors. My expungement bill also, automatic expungement bill also lists certain felonies that I've delineated. I have no angst whatsoever with Senator Lucas's bill. I just want mine to include all misdemeanors. I don't want to see a carve-out. I don't want to I don't want to go down that road. And I don't think anybody would object to a single misdemeanor that I would want to put in there. With regard to Senator Servill's bill, I'm sorry?
No, I was saying, and then.
With regard to Senator Servill's bill, Senator Servill's bill creates a fund to pay for the expungement of criminal records, and my bill, at the recommendation of the Crime Commission, introduced a $20 million budget amendment. I don't want to get too much into the weeds on that, and I'm not a stickler for Servill's or mine. That might be for debate, and I'm not drawing a line in the sand for that. Also, Senator Servill's bill allows for the petition of expungement. Well, I'm going to let him go into that.
Senator Morrissey, to be clear, though, your bill does not contain the third-party liability issue that has been addressed in the Serval bill and now in the Lucas bill.
It's not addressed in Senator Lucas's bill, I don't believe.
And the substitute is, I think. There's some language. Your bill doesn't address this whole issue of whether the employer is liable for the employee's acts.
No.
Okay. Okay, are there any other questions of Senator Morrissey?
No, ma'am. No,
Mr. Chairman, McDougal.
I have nothing else.
Dougal.
I mean, we're talking in a lot of generalities. I'd love to know specifically things like DUI, assault, domestic assault, brandishing firearm, hit and run. What are in what bills? So, Mr. Chairman, I know that we're saying most everything, a lot of everything. There are some, I'd like to know what misdemeanors are automatically expunged, petition expunged, not eligible to expunge in each of the different versions.
I think that the easy answer is in Senator Morrissey's bill, all misdemeanors are expunged. You have a little difficulty reading the bills because they don't refer to the crime themselves. They refer to the code section. You almost have to have 18.2, a title of 18.2.
Mr. Chairman, I've set forth both the code section and the bill itself, and I'm happy to go through the list of those felonies now that are automatically expunged.
Well, that would be a good idea.
And I'm also, if I didn't get home late last night, I would have made copies of this, but do you want me to do that now?
Yes, I think that'd be a good idea.
Certain felonies, 18.2-60, threats of death or bodily injury to a person or member of his family. 18.286, setting fire to woods, fences, grass, etc.
Mr. Chairman, I cannot hear Senator Morrissey.
Oh, you can't hear me?
Cannot.
Okay. Can you hear me now, Steve?
Excellent. Thank you.
All right, I'm sorry. The certain felonies that I have automatic expungement include 18.2-60, threats of death or bodily injury to a person or member of his family. 18.2-86, setting fire to woods, fences, grass, etc. 18.2-94, possession of burglary tools. 18.2-104, punishment for a conviction of a compound petty larceny. 18.2-126, violation of defilement of a dead human body. 18.2-127, injuries to churches, church property, cemeteries. 18.2-137, injuring any property or monument. 18.2-138, damaging public buildings. 18.2-145.1, damaging or destroying research farm products. 18.2-151, opening or carrying away pumps used for dispensing gasoline. 18.2, 152.3:1, transmission of unsolicited commercial electronic mail, spam. 18.2, 156, taking or removing waste or packing from journal boxes. 18.2, 250, possession of certain controlled substances. 18.2, 323.02, prohibition against concealment of dead body. 18.2, 328, conducting illegal gambling operations. 18.2, 468, making sound recordings of jury deliberations. 18.2, 471.1, destruction of human biological evidence. There's a few others. That's about it.
Those are the felonies plus all misdemeanors.
Yes, sir.
And that misdemeanors would include, to Senator McDougal's point, would include like a DUI 1 or DUI 2.
ALL.
Yeah,
No, just all misdemeanors.
Mr. Chairman.
No carve-out.
Senator McDougal.
Mr. Chairman, so, and I'm, just want to make sure I understand with this. So these are automatic after how long a period of time in
8 years.
Senator Morrissey's? How many?
8 years, sir.
8 years. And Mr. Chairman, I want to make sure I understand. They're automatic after 8 years and regardless of any other actions after you were found guilty of the offense?
Oh, no. No, you can't have another conviction. You have to have a stellar record.
So, Mr. Chairman, do I hear from Senator Morrissey that if you had a improper driving and then you got a speeding 7 years later, that couldn't be expunged?
No, that's a traffic conviction. If you look at
Right,
pages 12 through 13, lines 734 through 751, 8 years must pass without another criminal conviction. And I believe that, I know that's identical to Senator Lucas's bill. So your example is not, would include traffic, traffic convictions.
And we're going to have to get through these bills and the
What?
marijuana bill by 11 o'clock.
Mr. Chairman, I understand. I just want to make sure that, this is significant, and I want to make sure I understand. And when we get these substitutes, we can't pull them up on our computer easily. We can't highlight the code sections. We can't even click on them. So when we don't get them till we sit here, I think it's important that at least we go through that.
Absolutely is.
So, Mr. Chairman,
Senator McDougal.
with that, so if you can't have another conviction, but if you had a charge that was taken under advisement, then you still could have the others expunged. Is that accurate?
Is it directed to the
I would think
Chairman?
if that other, I think it was directed to you, Senator Morrissey, but I would think if that charge did not result in a conviction, you could get it expunged under Senator Morrissey's bill and probably under Senator Lucas's bill as well.
Mr. Chairman, I guess what I'm trying to ascertain, could you have a charge of, let's just say, domestic violence, then you have another charge that's assault or domestic violence. For some reason, a prosecutor agreed to take it under advisement or it went under the other under advisement statute. Would that be a bar to the prior statute being expunged? Or because the only restriction is a criminal conviction, it would not stop the prior statute from being expunged?
Mr. Chairman, a charge would not be a bar.
So, thank you, Mr. Chairman. When the appropriate time, I'll have some thoughts on it.
I appreciate that. Senator Lucas, do you have a similar list of bills that are subject to automatic expungement?
Mr. Chairman, I think it's administration. They're available, they can tell you exactly. Do you have it?
The Crime Commission's available?
I think they are.
Is the Crime Commission online? Somebody from the Crime Commission?
Yes, Mr. Chairman. Colin Drabert, I see, has his hand raised, so.
Okay, I would just like a rundown of the offenses that are expungible after 8 years automatically under Senator Lucas's bill.
Mr. Chairman,
Senator Servo.
I believe it's on lines 582 to 599 of the bill.
Of the substitute?
Yeah. But it's all numbers.
It's all numbers. It's
Yeah, right.
That's why.
I get it. I'm just telling you that's where it is.
Yeah.
Mr. Chairman, I think
And
what you
Mr.
wanted.
Chairman,
Okay.
Mr. Chairman, this is Colin Drabert from the Crime Commission. I do have a breakdown. The felonies would be this mostly the same as Senator Morrissey's. There are a number of misdemeanors that I could go down the list quickly, but there are a rather substantial number. What the Crime Commission did was try and go through the misdemeanors, exclude DUIs, any crimes of violence, domestic batteries, crimes involving firearms, and any other crimes that might not seem appropriate for automatic expungement, and that's what was
Senator
left behind.
McDougal's point, a conviction for domestic violence would not be subject to automatic expungement under this bill.
That is correct, Senator, Mr. Chair, that domestic battery is not one of the qualifying misdemeanors. There's no DUIs, no assaults, nothing of that nature on the Crime Commission list.
Mr. Chairman,
Senator Morrissey.
so to the direct question to the Crime Commission, so that two brothers in a family that get into a fist fight and resulting in a conviction for one or both, that would not be automatically expunged?
Mr. Chair, Senator Morrissey, that's correct, because for purposes of automatic expungement, there'd be no way to easily ascertain whether it was two brothers or a husband and wife or a relationship.
Further question.
Senator Morrissey.
Defendants convicted of a first offense DUI, .09, no prior convictions, a pedestrian DUI conviction, not automatically expunged.
Mr. Chair, Senator Morrissey, no.
Thank you. Mr. Chairman,
Senator
I
Morrissey.
can't agree to any bill that has these carve-outs. When we start mentioning DUI or domestic violence, certain stakeholder groups, their antennas go up. Not going to be a part of that. Automatic expungement for all misdemeanors. There's a reason why they call them misdemeanors and not felonies.
Okay. Are there additional questions or comments about Senator Morrissey's bill? What I'd like to do then is for Senator Servell to present his bill, and then we can open it up to the public and have more of a discussion. Senator Servell.
Thank you, Mr. Chairman. Senate Bill 1339 is a substitute. I'd move the substitute. Senator Edwards seconds.
Okay, do we have it up on LIS? 1339 substitute?
Mr. Chairman, I'm in the midst of posting that right now.
I've distributed to the committee, Mr. Chairman, so I can at least start describing it to the committee. I know the public
Okay.
probably won't get it for a minute or two, but
Well, we've had a motion and a second to adopt the substitute. All in favor, say aye.
aye.
Okay. Any opposed? Substitutes before you for 1339.
Thank you, Mr. Chairman. So first of all, I want to give a broad summary, and then I'll walk the committee through the bill by line number. I'm hoping we can use this as the vehicle to continue this discussion. So first of all, the bill makes a broad distinction between expungement and sealing. Expungement, and it makes different legal consequences for that. Expungement is mainly for people who are either innocent or actually innocent, as we currently have under current law, with a couple additions. Sealing is what this bill would do with convictions. In terms of expungement, it adds it also has a small automatic expungement provision, which I'll go over in a second, which can be built upon later. And the sealing, just broadly speaking, is for class 5 and 6 felonies all the way down. That is for convictions, sealing convictions. It also has provisions for employer access. It talks about the legal consequences of expungement and sealing, which the other two bills do not do. It has a court-appointed attorney program, which the other bill does not have. It talks about civil liability for data brokers, which is a bill that's been vetted by committees here before. Senator Lucas' version has some data broker thing I've never seen before. I don't know who's vetted that, but that's new. It wasn't discussed in Crime Commission. And there's a lot of other details that I'll talk about in a second. But the big difference is the House has a the Senator Lucas automatic bill has a small list of crimes, and it's automatic. This bill
The word you use has the what? Senator Lucas' bill has the something of
has a small list of crimes, but it's automatic.
Yes.
This bill has a big list of crimes, but it's mostly petition. That's the main difference. So this provides relief to more people, but they have to go seek it, as opposed to Senator Lucas's bill, as it happens by computer to a small list.
That is correct.
Yeah. And just so the committee has some background, we talked about this on the Crime Commission. 36 states allow the sealing of felonies. 41 other states allow this of convictions. 41 other states allow the sealing of misdemeanor convictions. About 4 to 5 states have authorized automatic expungement or sealing. Most states call it sealing after it's been convicted. Only 2 states have actually implemented that because it's very hard to do automatic. And only 1 state in America has authorized the automatic expungement or sealing of felonies. And it has not been implemented in that state yet because it only was voted on about 2 months ago. And most states exclude all the crimes that Senator McDougal has been talking about from their sealing or expungement. I'll just point that out as well. I believe we were presented that at Crime Commission. So here's the details. If you have the bill in front of you right now, I'm going to skip the first part of it because I'm going to have to go back to that. I think that's not really the main act in the bill. So if you want to turn to line 153, that's sort of where the expungement piece begins. Section 19.2, 392.1:1, this defines what expungement means, and it defines what sealing means. And basically, the first line there, it says expungement means we're removing everything from the record, and it's being put in a physically sealed and separate file, recorded in an offline medium pursuant to procedures adopted by the state police. And that's basically what happens today. A lot of people think expungement means records are deleted. They're not. They're putting in a file cabinet somewhere that only certain people can get to. And then in sealing, as on the next page, sealing says that all we're doing is restricting dissemination of the record information in the CCRE and prohibiting dissemination of court records. Those records are also, not seen in public anymore, but it has those definitions which are critical. Then if you go down, line 168, 19.2, 392.2, this is the existing expungement statute, and you'll see what we've added to that. In addition to the not changing existing law, we've added that people can petition to have alcohol possession, marijuana possession, and underage tobacco possession expunged, or convictions for that, or if they receive a suspended position of sentence. We call that an SIS, suspended position of sentence on those provisions. In order to get that, you have to have good behavior, no convictions of any kind for 5 years during that period of time. And then it also restores the payment of court costs, but it waives court costs for anybody who's indigent. So if you can establish that you're indigent, you don't have to pay court costs. One of the things we heard from our colleagues on the other side at Crime Commission is that access to court to people is important, and I'll get back to that, but this waives court costs if you can show you're indigent. Okay, then if you go down, and by the way, all the funds, these costs are paid into our new expungement fee fund, which is at the beginning of the bill, section 17.1205, line 102. That's the expungement fee fund. So all the people, whenever anybody does a petition-based expungement or sealing, the money goes into a fund, and that fund is then used to pay for court-appointed lawyers for people who are indigent who can't afford a lawyer to do their expungement petition. And I believe the fee for that we have in here is the same as a misdemeanor fee of $120, I think, to get paid for that. So then, if you go down to some other changes that I think are important, if you go down to line, the changes on the next couple pages just are adding the fact that we're expunging convictions, which is new for expungement. But it's a policy that the Courts Committee adopted the last 2 sessions, special session, the session before, I believe. I think it was Senator McDougal and Senator Norman's bill, maybe Stanley as well. Then if you go down to line 264, it makes clear that any kind of expungement proceeding, this also is repeated for sealing proceedings, are sealed at the courthouse. There's an inconsistent practice between courts. Some courts treat these as sealed proceedings, and some don't, but the code doesn't provide clear guidance to the clerks of court, so this takes that up and makes that clear at those lines. Then if you go down to line 284, this has, one other provision that's new on line 281, and this is a bill that the Senate Courts Committee adopted about 3 years ago, it makes clear that no Commonwealth attorney can include in a plea agreement a provision that prohibits a defendant from filing an expungement or a sealing motion. If you all remember that, at least in my experience, there was a Commonwealth attorney, a former one in Arlington, that used to make people sign plea agreements prohibiting them from seeking expungement for dropping things as minor as marijuana, as alcohol, drunken public charges. And this would make that against public policy and void. So then, just below that, line 284, this has to do with dismissals. Under the Lucas, Morrissey, the old Crime Commission bill, that bill required the automatic expungement of any kind of dismissal, regardless of whether or not the dismissal happened because of an evidentiary malfunction, a witness failing to show up, a husband intimidating their wife into not coming to court, something like that. What this bill does is this says that if somebody is acquitted or charges dismissed, then the defendant can orally ask the court at that moment of dismissal to expunge a charge, and the court can grant it at that moment as long as the Commonwealth attorney does not object. If the Commonwealth attorney objects, then the matter is not expunged, and the person can later seek expungement. It's a without prejudice denial, and the person can later seek expungement. Again, access to justice, we heard, was important. This eliminates the need to hire a lawyer to get a dismissal expunged. So the next, let me see. So next, if you go down to 19.2, 392.2, this is a brand new statute having to do with the sealing of convictions. So this is all new law at this point. And Senator McDougall, this gets to what I think you've been asking about. So if you look at lines 309 through 316, this says that except for a conviction of DUI or 341.24, which I can't remember what that is right now.
Mr. Chair, that is commercial driver's license DUI.
Oh, got it. Okay. So except for conviction of DUI or commercial DUI, anybody who's been convicted of a traffic infraction, a misdemeanor offense, or class 5-6 felony violation, or a violation of 18295, which I believe is the larceny statute, or grand larceny, or any other felony offense where a defendant is deemed guilty of larceny and has received a simple pardon, or has received a simple pardon, they can request sealing of the records relating to the arrest, charge, or conviction. They're only eligible to do that, however, if they have never been convicted of a class 1 or 2 felony, if they have not been convicted of a class 3 or 4 felony within the last 20 years, or they have not been convicted of any felony in the last 10 years from the date of the petition. So if you have any of those provisions, you're not allowed to seek sealing. Then, if you go to the next provision, B has to do with costs for indigent folks. Then C explains what the petition has to contain. D says the Commonwealth attorney has to file an answer. E has to do with getting your fingerprints done. F has to do with the criminal history information. And so what F is, it says that in order to obtain the sealing, you have to show, depending on what charge it is you're seeking to seal, uniform good behavior, that is, means no convictions, for a 3-year period if you're seeking to seal a misdemeanor. For a 5-year period if you're seeking to seal, a non-misdemeanor traffic offense. If you're seeking to seal a misdemeanor traffic offense, excluding DUI or moral turpitude offenses, you have to show uniform good behavior for 5 years. If you're seeking to seal a DUI, class 5 or 6 felony, or a moral turpitude offense, you have to show good behavior for 10 years. In addition to that, on line, you also have to show that if there's any indication in the record that you were addicted, you have to show that you're no longer addicted to drugs anymore. You have to show a manifest injustice, and again, it has the cost provision. You also can only seal 2 offenses in your lifetime, and we define an offenses arising out of 2 incidents. So if you have multiple charges arising out of 1 incident, that counts as one set for purposes of this bill. Then section 19.2, 392.2:3, this has to do with automatic sealing. which is the smaller version of what's been proposed by the Lucas Morrissey Crime Commission bill. So, if you look at the first part of that, lines 419 through 419 through 431, this says you can obtain automatic sealing for any class 3 or 4 misdemeanor that's reported to CCRE, a violation of alcohol possession, marijuana possession, or marijuana paraphernalia, provided that 10 years have passed from the date of disposition, and the person has not received any reportable offense to CCRE in the last 10 years. And those are reportable misdemeanors. So if you got a traffic conviction, that would not count. But if you got a DUI, it would. If you got a reckless driving, that would not count. If you got a driving on suspended, that would not count. But if you got an assault and battery, it would count. So you would not be eligible for the automatic sealing. You could, however, petition for a petition-based sealing. And you can only get 2 charges automatically sealed in your lifetime. And the rest of this section has mostly to do with logistics between the courts and the state police. Subsection G also is a difference with the Crime Commission bill, I believe, and this bill, and I assume the Morrissey and Lucas bill, which is that the list of charges that's transmitted by the courts to the state police for purposes of sealing are not public documents, they're sealed. The reason that's important is because there are a lot of people out there who would love to use those lists to put stuff all over the internet and extort money out of people. And it's important that that stuff stay sealed so that I can get into specifics if anybody would like. And then, let's see, what's next? Then, this is also important, lines 472 to 75 state that any class 3 or 4 misdemeanor or traffic offense that's not reported to CCRE are deemed sealed when they're destroyed by the General District Court. General District Court destroys records, I think, every 10 years, after 10 years. And so this would automatically deal those records as sealed as soon as they are destroyed. And that's important for purposes of these criminal background checks, these companies that put out information about people, that we specifically and legally state these things are sealed so that they can't continue to publish them to people. And that's also a difference between the bills. Then,
Can we just get an idea how much time we're going to allow for this, and then
I wanted to be able to walk through all 3 bills, then figure out what policy direction we wanted to go as a subcommittee so we could get to marijuana. I mean,
Can I just make a point now, and then Senator Servo can continue? I've got to tell you that I'm sitting here, and I appreciate all the work that Senator Servo did, but you'll need a PhD in criminal justice procedure just to follow all the nuances. I got a headache listening to, well, you can do sealing, but if you don't do the expungement, but you can do it if you didn't have anything in 20 years, but as long as it's not a class 3, I can't follow it. I'm just going to say right now, it is too complicated. It's not necessary. Let's keep it simple, okay? We can have a discussion between sealing and expungement, but to break this down into all these various nuances, as long as you didn't have a misdemeanor traffic conviction, but if you had a traffic infraction and it only occurred within 2 years when you were wearing orange socks, it's too complicated. It's way too complicated for the average practitioner and judge to follow.
Mr. Chairman?
Senator Lucas.
Yeah, and I quite agree. And I thought one time it was just my sense of confusion. But certainly if Senator Morrissey is having difficulty following, you know how much difficulty it's going to be for the average layperson. And I think therein lies a problem with, and especially with some of this, the NAACP and other organizations that are supporting expungement bills. This is exactly the problem that they're having. They're saying if you make it difficult, this difficult, people still will not be able to get their crimes expunged. It's way too difficult.
What is this incessant concern with a DUI conviction? You know, I'm so tired of hearing that.
Mr. Chairman.
It's a significant offense. I understand it. It causes carnage on our highways, but all I keep hearing is DUI. I'm going to say this publicly. So what?
Mr. Chairman.
Mr. Chairman.
Senator Servo.
I appreciate Senator Morrissey's opinion, but the federal government requires us to keep DUI records public for 11 years or we lose a lot of money. It's not our decision.
Senator Servo, your bill, does it address the employer liability piece that was brought out in Senator Lucas's substitute?
Mr. Chairman, the difference, my bill does not have an employer immunity provision in it. My bill does have a data broker liability provision in it.
Okay, the third-party liability part.
Yes, it does.
Okay.
But I do not have immunity in here. But what it does have that's different is that it allows different classes of employers to ask about expunged charges and to seek and to request disclosure of certain expunged charges depending on the nature of the job. And by the way, for whatever it's worth, what this bill does is basically what's done in the majority of states in America. And yeah, it's complicated because the world's complicated and because different offenses have different consequences and different reasons for occurring, and there's different things that have to be, circumstances that have to be taken into account to decide whether or not to keep it on somebody's record or not. The world isn't simple. In fact, from my perspective, Mr. Chairman, oversimplification is what led to mandatory minimum sentences. People thinking that it's just easy, everybody's a criminal, they should get them out of jail time. That's I think, a big policy difference.
Senator Servo, are there just a few minutes worth of explanation you have left for your bill?
Sure. I can get, I just thought, okay, I'm happy to finish blasting through it right here. Section 19.2, 392.3:1. That starts on line 507. That has to do with how these records can be disclosed, mainly by the permission of the subject of the record. It also talks about different people that have access to these records. And then if you get to section 392.5, this is another provision that the Crime Commission bill and the House bill, these other two bills don't deal with. It talks about what the legal effect of an expungement is and what the legal effect of sealing is. Nobody likes to talk about what the effect is, but by adding all these crimes, it creates all kinds of confusion and all kinds of unintended consequences by not specifically defining what the consequences are. So subsection A has to do with the legal effect of expungement. Subsection B has to do with the legal effect of sealing. Section 19.2, 392.6 also talks further about sealing and explains when these things can be admitted in evidence, when they can be used for sentencing in subsequent charges. They talk about barrier crimes, which we haven't even begun to talk about yet, about whether or not expungement removes a barrier for barrier crime purposes, and nobody's talked about it except in my bill. And it also makes clear that any charge or conviction sealed shall not be maintained, sold, reported by any third party unless it's in accordance with this chapter, and that's for the data brokers. Then the last thing, Mr. Chairman, is if you look at subsection, if you look at the very beginning, subsection 20, lines 25 through line 81, this has to do with the data broker liability piece, which makes basically any company that buys and sells information containing public record information liable if they continue to publish inaccurate information, as if they continue to publish information about charges that have been expunged. Because if we give people an expungement, but third parties continue to put it on every background report for everybody who applies for a job or everybody who applies for a lease, we haven't done anything for anybody. And the bill that was approved by the Crime Commission didn't have anything about that. And I guess now there's some new language that's been proposed, which I haven't even read about that.
I'm sorry, I'm sorry to interrupt, but the Crime Commission is on the line. Could we please have them to speak to that?
Yes, Mr. Chair, Senator Lucas, Colin Draper from the Crime Commission. There was new language added to the Crime Commission legislation that specifically dealt with criminal record information that was obtained and sold by third-party vendors. That legislation was drafted based on statutes out of Minnesota, North Carolina, I believe, as well as Louisiana, that had dealt with their third-party vendors, specifically in their expungement statutes limited to the issue of criminal information. That in the third-party background portion, we've reviewed that with some individuals from the industry, as well as the Legal Aid Justice Center, seeking feedback on that to try and fine-tune it.
Mr. Chairman, I have a question,
Okay,
Mr. Draper.
The third-party liability language you got holds these data vendors liable for dissemination of that information?
Mr. Chair, yes, it does. It holds them liable. It creates essentially a process for state police to make them aware that a charge has been expunged so that it can be removed from the record. And then if they do not remove it, there is liability both through the individual as well as enforcement powers through the Attorney General's office.
Have you compared that language to the language in Senator Serval's bill?
I have, Mr. Chair, we have looked at the language in Senator Serval's bill. I've not had a chance to delve into whether it changed during the substitute. For the introduced version, the main difference would be that Senator Serval's data broker seems to go beyond the information about strictly limited to the criminal charges. It gets into consumer information, tax liens, outstanding judgment, things of those matters that went beyond what the Crime Commission language did in terms of focusing more on the convictions and charges.
Okay,
Mr. Chairman.
Senator Serval, yeah.
I have a question, Mr. Draper. You know, I'm new to the Crime Commission. I'm not really familiar with its processes, maybe as I should be. But first of all, it's accurate to say that what you just described has not been reviewed by the members of the Crime Commission, voted on or approved. Is that right?
Mr. Chair, Senator Serval, correct. That issue of third party has not been presented to the Crime Commission.
Okay, thank you, Mr. Chairman. One other question. Mr. Chairman, is it the Crime Commission's habit to speak on behalf of the Crime Commission without getting the approval of the board of the Crime Commission before speaking, or about a language that belongs in a bill? Or I'm trying to understand the process here.
Mr. Chair, Senator Serval, what I will state is the Crime Commission had requested that staff look at the third-party language. We did not have time to do that prior to special session. However, we did prepare or work on that prior to the regular session. And we're speaking on behalf of the legislation, both as staff as well as on behalf of Senator Lucas's bill, which was amended to include the language staff had worked on.
Okay, thank you very much. Okay, are you done, Senator Serval?
I'm done. I would move my substitute, Senator Edwards, seconds. I'd move to report it.
Okay, we've got
Aren't we going to hear testimony, Mr. Chairman?
Yeah, we are.
hear from the public before we have any motions.
I thought we were going to hear from the public before we start passing any bills.
So I was going to do 5 minutes on each side, but I think we probably have 3 bills. We'll do 10 minutes total of public comment. And I understand that a lot of people are signed up. We might not have much more time to identify yourself, identify any group you're associated with, and tell us your position, which bill you're for, which bill you're against. But be quick about it.
We have our first speaker, Lauren Penn. Andy Elders, please go ahead.
Hi, good morning. Andy Elders with Justice Forward, Virginia. With due respect to the chair, I'm not sure that it's possible to say I favor this bill or that bill. The provisions here meet some of the priorities that we have as an organization. Some of the bills meet it on some topics and some meet it on others, so I'm going to try to buzz through those as quickly as I can. The goals overall are broad automatic expungement, which I believe we're seeing a lot of out of Senator Lucas and Morrissey's bill. Broad categories for expunging convictions, including felony offenses, which we see out of Senator Serval's bill, and categories of immediate expungement for null process, dismissals, and acquittals. Each of these can be broader. Overall, the message is more is better, but I do want to highlight that I appreciate what Senator Serval has in terms of third-party liability and the sentencing guidelines provision specifically, which is important to criminal defendants whose prior record has been expunged. So there's a lot going on in these bills. I'm hopeful that we can take eventually, in whatever setting, some of the best pieces from each of these bills and put them together into one bill that makes sense, is comprehensive, and is also broad-based and gives access to people who desperately need help so that they can get their records cleaned up and they can move on with their lives. I thank you for the time, and I hope that we'll report a good bill out of this committee.
Thank you so much. Next.
Lauren Penn, please go ahead.
Good morning. Can you hear me okay?
Yes, ma'am, we can.
Okay. My name is Lauren Penn, and I am a someone who these bills will personally affect. I currently am, I got a criminal background over 12 years ago. I have made great strides. I've not been in any more trouble. I went back to school. I'm getting ready to finish my bachelor's. I read all the expungement bills. Senator Lucas's bill and Senator Morrissey's bill, the way that it is laid out, I will not be eligible for expungement under this bill. But under Senator Serval's bill, I will be eligible for expungement because Senator Lucas's bill and Senator Morrissey's bill is too exclusive, in my opinion. And Senator Serval's bill, to me, seems like it has a heart. Now, I am a lay person. I sat here all last night. I read all of the bills. I was able to understand Senator Serval's bill. And to me, out of the three, people who have petition-based expungements, and there was a study that was out last year in Michigan, and I'm sorry I'm rambling. I just kind of went off script, but less than 4% of the people who are eligible for expungement actually go and find expungement opportunities within 5 years of them being eligible. So by us expunging records and by us filling records, we're not just saying, everything is forgiven. We're actually giving these people opportunity for hope and a clear path for success. And so if, like the man said before me, we could take the best parts of the bill and maybe put them together, I think it would be really good. But in my research, what I've learned overall, I think Senator Serval's bill is best fit. Also, if I could add, Senator Lucas and Senator Morrissey's bill has a clause in there, Section D. It's around line 700 and something, where it says if your charge has been reduced from a greater charge that's not expungible, then that reduced charge is not eligible to be expunged. And with what we've known and what we've learned off of plea bargains and how sometimes they're not given in the best interest of the defendant, but rather to gain a conviction, or it may be racially increased, I would just ask that you would eliminate that clause D.
Thank you very much. We've had two speakers and eaten up 4 minutes. Who's next?
Christy Wright, you're our next speaker, and Gayleen Kanaton, please go after.
Good morning, Mr. Chairman, members of the subcommittee. Christy Wright, Office of the Executive Secretary, Supreme Court of Virginia. We have no position on the bill as far as the policy. Our focus is on our ability to do it and ensuring that we have the resources to implement this. Just as far as our perspective, Senator Lucas and Senator Morrissey's bill are strictly auto expungement. We had worked on the substance of that with the Crime Commission during the summer. We know we can implement those, and our costs are related primarily or exclusively to the technology. Senator Serval's bill, we've also been working with Senator Serval and addressing some of our concerns just regarding implementation, and we'll continue to do that. I haven't had an opportunity to fully look at the substitute. This particular bill has both the by petition, which involves clerk time, as well as the auto, which is the technology piece. And so with that, any fiscal impact would involve both of those items. I would ask that regarding the automatic expungement, if what is anticipated is what is in the Crime Commission's bills regarding auto expungement, we would need a longer delayed effective date. My understanding is that state police needs a longer date if we're going to do this all automatic or all through electronic means. And our implementation is based on integrating it with their implementation. So, and then finally, I know you all haven't brought this up, but there is an expungement piece in the marijuana bill. That one, it's less clear as to what is intended. There seems to be both an automatic tied in with a manual process that requires the clerks to pull documents and files off the shelf and go through the regular expungement process. So with that, there is both the cost for automation.
We haven't even gotten to the marijuana bill yet, but
Right, but and I just thought you had wanted an overview of all the various, and so I'm happy to speak to that again. But anyway, there are some implementation concerns with that, and we have reached out to the Secretary's office regarding that. Thank you.
Thank you very much. Who's next?
Gayleen, please go ahead.
Good morning. My name is Gayleen Kanoyton. I am the Virginia State Conference NAACP Political Action Chair. And for the sake of time, I'm just going to cut to the chase. We are in strong support of Senator Louise Lucas' bill. We are not in favor of any petitions or any barriers or anything that's going to line attorneys' pockets. For the sake of getting expungement, we believe that people who have served, who have 8 years without any incidents whatsoever, pay taxes, that they should have their offenses automatically expunged. So we ask that please support Senator Lucas' bill. Thank you.
Thank you very much. Who's next?
Leonard Bennett, please go ahead.
Good morning, Chairman. My background is in this very area. The edits to Senator Lucas's bill cured the big opposition that myself and as on behalf of the different consumer groups I've spoken on behalf of before had last summer. And then I think that Senator Morrissey would likely agree with those. All three of these bills are a vast improvement over what was in place in the summer. The big differences on that single issue and the substitute of Senator Lucas's most recent bill, starting at line 1021, would provide a remedy that models the Fair Credit Reporting Act. The one thing that I think has to change is line 1062 and 1063. The very last sentence says a business screening service that complies with this subsection is not in violation of the section. This subsection is a consumer after the fact can make a dispute. So after a consumer has been denied a job, then they can make a dispute. Normally, currently, background check companies already correct after dispute. It's too late. They've already lost the job. They already have not been able to get the apartment. And so that sentence nullifies the entire section that would otherwise be here. The only other change I would suggest, Chairman, is if you look at Senator Surivel's bill, it's much stronger in a lot of ways. And I'm referring to his substitute in the beginning, starting at line 52, which is data brokers shall. Senator Lucas's substitute, as commendable as it is, does not have all of the protections that are in Senator Surivel's bill starting at 52, which would be a subsection B, data brokers shall. If you were to add 1, 2, 3, and 5, subparagraphs 1, 2, 3, and 5, that gives consumers the right to obtain a copy of the criminal records information that would be necessary for them to determine whether or not the expunged or inaccurate record is in place. And this matters, and I think this you heard from us last session, is that nobody actually goes to the court to do a background check. They buy from these big, giant private databases. That's where, candidly, I've made my living. We've got injunction after injunction trying to do what you can do here instead of our whack-a-mole. That solution, that combination of Senator Surivel and Senator Lucas's bill would put Virginia more in line with the other states and go quite far to protecting our citizens.
Okay,
thank you
so
for all
much.
of your time.
Yes, we've got about 30 seconds left and about 5 or 6 more speakers, so please be quick.
Chris White.
Good morning, Mr. Chair and members of the subcommittee. I'm Chris White with the Vector Corporation. I'm here on behalf of Relix. We're the parent company of LexisNexis. Relix doesn't have a position on the methodology of expungements or which offenses should qualify. Those matters are best left to the General Assembly. What I hope to try to address is the third-party liability issue between Senator Lucas's bill and Senator Surivel's bill. The concept that Senator Surivel has incorporated into his bill regarding data brokers was examined by the Senate Judiciary Civil Subcommittee in 2020, and it was not advanced. Instead, the request was to have the Joint Commission on Technology and Science review that policy, but because of the pandemic, they were not able to give it a proper and comprehensive vetting. Now that concept is incorporated into the bill related to expungements as a way to try to ensure that an expungement is meaningful.
Chris, we got to wrap it up.
Okay, essentially, Mr. Chairman, Senator Lucas's bill provides a meaningful expungement because the big difference is it has a notice provision. So a third-party custodian of data will get notified that an expungement has happened and will be able to fix their record. Senator Lucas' bill also has a requirement that the order is destroyed, so there's not a list floating around. Senator Surville's way of addressing it with private rights of action and suing your way to try to get accuracy will not provide a meaningful expungement for people trying to get their life back together.
Okay, thank you so much. Okay, we're out of time, but we still have speakers. I'm going to give you 30 seconds each, and that's going to be sharp. You're going to be cut off after 30 seconds. So please tell us who you are and what your position is quickly.
Sheba Williams and Sierra Tisdale-Vacos, please go after her.
Good morning. My name is Sheba Williams. I'm the executive director of No Left Turns. I echo many others in thinking that these three need to be combined, but expungement needs to be free, automatic, and as expansive as possible, and no longer making money off of the backs of poor Black, brown, and marginalized individuals. I gently suggest being more in line with DOC's data of 3 years instead of the 8-year waiting period. Thank you.
Thank you.
Good morning, my name is Sierra Tisdale-Vacos, and I'm a student at the University of Virginia and a member of Students for Equity and Reform in Virginia. And we support the automatic expungement process proposed by Senator Lucas. We believe that the bill creates a fair and equitable process for allowing expungement, regardless of an individual's economic status or other resources. I previously interned with an organization that helped reentry for previously incarcerated individuals, and I believe this bill could have really helped a lot of those individuals. So I urge you to support the Senate Bill 127.
Thank you so much. Next.
Keith Martin, and then Rob Pogenglass, please follow after.
Hi, Mr. Chairman, Keith Martin with the Virginia Chamber of Commerce. We've recognized, most of you, that a prior conviction can make reentry into society and the economy challenging. We'd like to thank Senator Surville for reaching out to the business community to seek a solution that meets the needs of employers and those with previous arrest and conviction histories. Thank you.
Thank you. Next.
Mr. Chair, Senators Rob Pogenglass with Legal Aid Justice Center. I wanted to endorse Mr. Elder's comments from earlier. We think there are great provisions in all of these bills. As a legal lawyer, a lawyer who handles expungement cases, I just want to flag one issue I've experienced with the current petition-based system, which Senator Surville's bill greatly expands. The fingerprint requirement, which cannot be done by lawyers, often grinds this process to a halt. It is extremely difficult for individuals who need expungement to get to a law enforcement agency and get fingerprints done. I'd ask that that provision be removed.
Thank you so much. Who's next?
Philip Thompson and Clayton Medford, you're after him.
Yes, this is Philip Thompson, President of Diverse Engagement. We support Senator Lucas's bill. We also like some of the things in Senator Surville's bill. We think expungement should be automatic and inexpensive. And we hope that we also have a carve out for marijuana convictions, because we have people now making millions of dollars in this state on marijuana and people that are still suffering from the impact. So we hope there's a carve out through the marijuana legislation.
Thank you so much. Who's next?
Clayton, please go ahead.
Mr. Chairman, members of the subcommittee, my name is Clayton Medford. I'm speaking on behalf of the Northern Virginia Chamber of Commerce. We greatly appreciate Senator Surville's approach to record sealing and expungement. He described very well the issues with automatic expungements, particularly with the context around dismissals and convictions. It's not a simple undertaking to remove the barriers to full employment that returning citizens face. We believe, and there's data to show, that greater access to consistent, reliable information about a job applicant who has a criminal conviction in his or her past would lead to greater employment than automatic process. So we ask you support his approach. Thank you.
Thank you so much. Who's next?
Marty Jewell, and then Fred Helm, you're our final speaker.
Good morning, ladies and gentlemen. I'm Marty Jewell, Chair of Cannabis Equity Coalition of Virginia, former city councilman here in Richmond. We support Senator Lucas and Senator Morrissey's bills. I don't see a dime's worth of difference in them. They're both very comprehensive. We do want to add the caveat that extensive effort be made to educate the public on how to get their records expunged and sealed so that in Black and brown communities, that information gets all the way down to the ground. We thank you.
Fred Helm, please go ahead.
Good morning, Mr. Chair, members of the subcommittee. Fred Helm, Kemper Consulting on behalf of the Consumer Data Industry Association. The reason we support the provisions of the Crime Commission in Senator Lucas's bill is because those provisions obtain accuracy on the front end, and we know about the records and they get updated accurately, and that's what we all want at the end of the day. Unfortunately, Senator Servel's approach results in somebody having to go sue in order to get a record updated accurately. So that's why we support Senator Lucas's approach and the Crime Commission.
Okay, thank you so much. Okay, now the problem is as more people have spoken, more people have put their hands up, and the reality is we don't have all day. We've got to get this done. We've still got to get to the marijuana bill, and that's a 1,300 line undertaking. So we're not going to take any more public comment on the marijuana, on the expungement bill right now. The bills are before the committee, or the subcommittee, and I'd like to know what your views are or what you want to do with them.
Mr. Chairman.
Senator Servo.
I think what the public testimony has suggested is that there's some people see merit in all of these things. But somebody just sent me a quote, which I think is very prescient, from H.L. Mencken. It says, "For every complex problem, there's an answer that is clear, simple, and wrong." So this is a complex problem. And complex problems often require complex solutions. It might not make people happy, but that's the reality, okay? And I think we need to have a vehicle that we can use going forward that incorporates all the concepts so that we can get a discussion piece to work with, probably get this thing into conference. It's going to have to, the House, I think, is taking a radically different approach. And so, Mr. Chairman, having said that, I would move that we incorporate Senator Lucas and Senator Morrissey's bill into Senate Bill 1339. And then, if we want to talk about amendments to that, maybe, a different automatic list or something like that, or any of the other details, we can talk about that. But I think that's the more prudent course of action. And Senator Edwards seconds my motion.
Mr. Chairman,
Senator Lucas.
Yes, sir. I would like to have those bills incorporated into my bill.
Mr. Chair, insofar as Senator Lucas agrees that my automatic expungement bill, which is identical to hers, except for it includes all misdemeanors, I would like those two bills incorporated into mine, and I will concede that the convictions for DUI, because they affect federal funding, I'm willing to carve that out from my all misdemeanors. I have one other, thank you.
Mr. Chairman, over here. Nope, Stanley.
I apologize.
Mr. Chairman, it is apparent to me, by having this great honor of sitting on this subcommittee, number one, that you're an incredible chairman, and I wish you'd be moved up to the major leagues from this AAA ball club that you're at right now. I think we'd be going home a lot earlier in the bigger committee. But
thank you so much.
Number two, it may have been wise at the time to put these three illustrious senators who I love and enjoy very much and consider all friends.
Client.
Client. But it appears to me, Mr. Chairman, that much in the same way that when my three children all want the same thing and there is only one of them, that sometimes the preference that is hard to make must be made. And so I would suggest, Mr. Chairman, subject to your approval, and certainly you can think differently, but perhaps this committee should take a vote on its preferences, and then that's what is presented to the full committee, unless we are eliminating two.
Well, in general, Senator, I would say we operate on motion, and a motion's been made and seconded that we operate with the Servel bill, and I guess that My preference would be that we continue to operate on motions, and if one's defeated, another one comes up.
Yes, sir. And so I think we should probably dispose of the first motion and then go to the second motion and the third motion and see where we are on each.
I think that's all we can do from this standpoint.
You're the greatest chairman I've ever sat with in a Judiciary Committee, I must tell you that.
I doubt that, but Senator Morrissey.
Given Senator Stanley's comments, would Senator Lucas agree to roll her bill into mine, since ours are identical, but mine is more expansive in that it includes automatic expungement of all misdemeanors, with the understanding that we'll address DUI later on?
Mr. Chairman, of Senator Morrissey, it would be just as simple to roll his bill into my bill, since they are almost identical, and then we can work from that framework.
And since yours contains an issue related to the data vendors.
That's correct.
But yours also contains a provision that grants immunity to employers in certain situations.
That's a good point, Mr. Chairman.
Probably not acceptable to too many
Mr. Chairman, that's Mr. Morrissey.
You can go to him first and then come to me.
That's a good point, Mr. Chairman. And Senator Lucas, would you, if I rolled my bill into yours, would you consider and be strongly inclined to incorporating all misdemeanors for expungement?
Inclined.
In that case, since the Senator Lucas is amenable to expunging all misdemeanors, I will gladly incorporate my bill into Senator Lucas's bill.
McDougal has
legislative survivor island.
It seems to me we've got a motion on the floor. Unless you're making a substitute motion, if this motion fails, we can get to Senator Morrissey's motion. But Senator McDougal has something to say.
Mr. Chairman, I am going to make a substitute motion, and that's that we move forward the concepts of the data that are in Senator Lucas's bill. I like the employer protections that are in Senator Lucas's bill, and then the rest of the provisions that are in Senator Survell's bill. That we make my motion is that we make those the recommendation of the subcommittee to the full committee. I don't care whose bill it is, but the points. Making sure we get that part right are important, and y'all can fight about the rest
Senator
of it between
McDougal,
now
let me ask you a question.
next week.
What if the employer has actual knowledge of the offense that's been expunged?
Right.
Should he have immunity in that situation? Because I think that's what Senator Lucas's bill opens up. If
It does.
Actual knowledge and still immunity. Is that what you think?
Mr. Chairman, let me make sure I understood. So if the employer knows that a larceny offense occurred, let's say it's an embezzlement from the employer, and they want to tell everybody in the world, they have immunity.
No. If they know that a person's been convicted of an offense and they hire that person anyway, and knowing that the offense has been expunged, but they know they have actual knowledge of the offense, they hire the person, and then the person does something while employment that affects a third party, for example, that was predictable because of their actual knowledge.
Mr. Chairman, let me alter my motion, since that seems to be, we move forward the data protections that were talked about in Senator Lucas's bill and the other provisions in Senator Survell's bill. Those are what we present to the full committee.
I'll second that motion.
Okay, so you would substitute the data protections that are in Senator Survell's bill. You would substitute those with those provisions from Senator Lucas's bill.
Yes, Mr. Chairman.
Okay.
I'll second that motion.
First, let me just move to roll my bill into Senator Lucas's bill, and then we can take up McDougal's motion.
Okay. Well,
I'll second that.
Okay. There's a motion to roll Senator Morrissey's bill into Senator Lucas's bill. And that's been, all in favor say aye.
Aye.
Aye. Okay, opposed, no. Okay, Senator Morrissey's bill is now in Senator Lucas's bill. Then we're going to Senator McDougal's proposal to roll the data breach provisions of Senator Lucas's bill into substitute those provisions for the similar provisions to Senator Survell's bill.
Yeah, and I'll second that motion.
Okay. Does everybody understand that? All in favor of that, say aye. Opposed, no. Okay, so, am I correct that we've rolled those into Senator Servell's bill?
Mr. Chairman, I don't care whose bill it is. I just want to make sure that as we're moving forward, that the provisions are the right ones. I don't know that I'm ultimately where I'm going to be in supporting it, but of the options that were presented, if something's got to move forward, I think that the limited automatic expungement in Senator Servell's bill with sealing is a better option than universal automatic expungement. But Senator Lucas's bill regarding the information and data is a better provision. I want to make sure that's what we're talking about. I don't care who gets the credit.
Who gets credit either. So is there which way are we rolling? Which number are we going with?
I would prefer to go under 1339, and I believe Senator Lucas would prefer to go under hers.
You're absolutely correct.
Okay, do I have a motion, one way or the other?
I already moved mine, I thought, but I don't know.
Okay, you did move that before we had this other discussion. Senator Lucas, are you on this subcommittee?
No.
You, okay.
I wish I were so I could vote.
Okay. Okay, we've got a motion to use Senator Servell's number with the, is that motion been seconded?
Parliamentary inquiry. It is my desire to move Senator Lucas's bill, not Senator Servell's bill, would that be the proper thing to be a substitute motion or simply vote no to Senator Servell's motion?
You could certainly make whichever substitute motion you want.
All right. My substitute motion is to roll SB 1339 into Senator
1372.
into 1372.
Okay. And we've got a motion and a second.
Mr. Chairman, McDougall again. I don't have a dog in this fight, but it seems to me we're the subcommittee. Why wouldn't that fight be in the full committee? Whose bill gets rolled what way? We present the concepts up. It's going to have to be a substitute presented, and then y'all can work that out amongst yourselves over the next couple days instead of us spending all this time figuring out who gets what bill what way.
I would like to, Steve Benjamin, I think, wants to speak, but Steve, I will tell you, we have less than an hour and a half to do the marijuana bill, assuming we get done with this right now. So what's going on? Steve Benjamin.
Please unmute
Steve, you're
yourself.
on mute.
No, please unmute yourself.
Steve Benjamin.
Okay, here I am.
Yeah.
That's what I was going to say, Mr. Chairman. Both Charles and I are here as attorneys to the subcommittee, and I simply want to note that our silence on these bills should not be equated as approval. There are too many moving parts for us to meaningfully participate or contribute on this. The policy behind each bill is sound and is good. Each of these bills has good features. Each of these bills has unintended consequences and logistical problems. And so I think we both endorse the idea of one vehicle going forward and being identified. And that is when I think we can be most helpful as attorneys and address these other problems.
I thank you very much for that. I like the idea of us having a number as we go forward, and when we get to the full committee, that can be undone. But we've got a substitute motion right now that basically from Senator Morrissey that would use Senator Lucas's number, but the bill that we've already agreed on, I think, is that we use the provisions of Senator Servell's bill with the data protection provision of Senator Lucas's bill. Senator Morrissey's bill is that we substitute motion, which has been seconded, is that we use Senator Lucas's number. All in favor of that motion, say aye. Okay. All opposed, no. No. Okay. That motion fails. We fall back on the primary motion, which is to use Senator Servell's number The role of the provisions in the Senator Servel's bill. By provisions, I mean that we are substituting Senator Lucas's data protection provision in substituting that language for the language in Senator Servel's bill. The rest of Senator Servel's bill is what we're using, okay? And the motion is that we recommend reporting that bill to the full committee. All in favor say aye. Aye. Opposed, no.
May I have a roll call?
Sure.
Just to make sure. Senator Servel. Aye. Senator McClellan. Aye. Senator Morrissey. Senator Stanley. Aye. Senator McDougal. Aye. Senator Edwards. Aye. And Mr. Chairman.
Aye.
Thank you.
Okay, now we're on to the main event, which is marijuana. And we've got roughly until about 11:15 to get this done, so less than an hour and a half now. Senator Lucas, are you going to present that bill as well?
Yes, sir, Mr. Chairman.
Okay.
Let me pull up my document.
My bill rolled into Scott's bill 1339.
Okay, we'll do that in full committee, yeah. Senator Lucas.
Okay, then I'll just stay right here then.
1406.
Yes, sir, Mr. Chairman. Thank you very much. Let me just give you the big picture, Mr. Chairman. From 2015 to 2019, over 23,000 Virginians were arrested for simple possession of marijuana. That's nearly 5,000 Virginians a year. Black Virginians are more than 3.5 times as likely to be arrested for marijuana despite using a similar rate to white Virginians. JLOC found that racial disparity was true in localities across the state in every region. The General Assembly acknowledged that injustice last year when we decriminalized simple possession. It was a good first step, but more is needed. This bill is the next step. It lays out a three-path to create a regulatory and licensing structure that promotes diversity participation in the industry, ensures that the product is safe for consumers, and updates the criminal code to reflect legalization of marijuana for adults over age 21. It also creates an expungement process for marijuana-related crimes. Let's right the injustices of prohibition and make Virginia the 16th state to legalize sales. Mr. President and Mr. Chairman and members of the committee specifically, generally the penalties in the bill mirror those that exist for liquor and can be found in ABC's code section title 4.1. Now, how does the bill punish underage less than 21-year-olds? The bill ensures that young people attend substance abuse classes and does not create the possibility of a criminal record for the first offense for those under age 18. First offense equals a civil penalty of up to $200 and mandatory substance abuse treatment classes and courses. Subsequent offenses equals class 3 misdemeanor and mandatory substance abuse treatment courses. 18 to 20-year-olds, first offense, civil offense of up to $250 and mandatory substance abuse classes. Second offense, class 3 misdemeanor. Third or subsequent offense, class 2 misdemeanor. The bill does not change Virginia's DUI law. Mr. Chairman, let me repeat that. The bill does not change Virginia's DUI law, which is currently impairment-based. Senator Adam Eben and I introduced a budget amendment to provide training for drug recognition experts beginning this summer. This training allows officers to recognize indications of when a driver is high on marijuana or other drugs. This is not accurate test like a blood alcohol for marijuana because the blood metabolizes the drug differently. Additionally, consumption while driving will be punishable by a class 4 misdemeanor. This mirrors the open container law for alcohol. This bill automatically expunges marijuana misdemeanors, simple possession, misdemeanor possession with intent to distribute marijuana, and misdemeanor distribution of drug paraphernalia convictions. Relevant agencies like the Virginia State Police will clear the records in their possessions. No further action is required of the individual with the eligible conviction. This bill also includes language for petition-based expungement of felony possessions with intent to distribute marijuana. Governor Northam has included funds in the budget for fiscal 21 and 22 so that expungement can begin immediately. up to 2 mature and 2 immature plants per house. The bill, excuse me, Mr. Chairman, does the bill let people grow marijuana at home? That's a big question. Yes, it does. Up to 2 mature and 2 immature plants per household, not per person. Only 2 of the 15 states that have legalized marijuana doesn't allow home cultivation. Washington and Illinois and the IL also for medical plants. 4 plants is less than every state that allows home cultivation except Maine. It can only be grown at a person's main place of residence, cannot be visible to the public, and must be out of reach of people under 21. Individuals cannot sell marijuana without a license. For people who grow more than is allowed, the bill sets an escalating penalty depending on how many plants are being grown and the number of infractions. The question is also asked, can a person be guilty of a crime if they have too much marijuana? Not unless they have 5 pounds or have the drug in places where it's forbidden, like on school property during the school day. An adult can only have up to 1 ounce of marijuana on their person or in public. If they have more, the penalty is a $25 civil fine paid like a parking ticket. Does the bill make public consumption illegal? Yes. It is a class 4 misdemeanor, up to $250 fine. No possibility of jail time. What other crimes are in the bill? The bill generally reflects ABC code. Some examples include having or consuming marijuana while driving a school bus, a marijuana business failing to pay taxes, selling marijuana without a license, a business knowingly selling marijuana to someone under 21 years of age, bringing marijuana across state lines, and illegal advertising.
Thank you, Senator Lucas. The 263-page, 1,300-line bill, 13,000-line bill. I guess everybody on the subcommittee has this.
Yes.
And the substitute doesn't need to be adopted. This is the substitute from the Rehab Committee.
This is it.
Okay, so this bill has already been through the Rehab Committee. The reason it's here is for us to review the provisions related to the criminal code and related to criminal penalties. And I wonder if maybe Charles and Steve could help us with some of the criminal aspects of this bill. What remains of the offense of possession of marijuana or illegal growing, or what sort of criminal code implications are contained in this mammoth bill?
Mr. Chair, what I would say is the criminal code provisions start generally on lines 7705 and continue basically through 8009. One of the things that I think we did notice in reviewing this was the venue provision for possession of marijuana seems to be a little stranger than most normal venue provisions, and that's on lines 7803 to 7805, and it basically provides that such person may be prosecuted in either the county or city in which the marijuana products were possessed or consumed, or in the city or county in which the person exhibits evidence of physical and of consumption of marijuana or marijuana
Mr.
product.
Chairman.
So I guess that would apply if the guy obtained the marijuana, say in the city of Richmond, but exhibited that he was high in Henrico County.
Right, Mr. Chairman.
Senator Servell.
Thank you, Mr. Chairman. That sentence was actually put in at my request or my suggestion by the governor's work group because we had to make that change to the alcohol possession law, I think about 12 years ago, because the Court of Appeals finds that once you consume something, you no longer possess it. Because once it's inside your body, you no longer have the control over it to decide when it gets metabolized or lost. And so in order to establish venue of a possession case, you have to have that language, or else you can never do possession on a constructive possession case. So that's why it's in there.
All right. And I'll say, I mean, basically everything else in terms of what's been, I guess, looked over and transferred over, seems to track, what would possession of unlawful possession of marijuana outside the purchase channels, growing, underage possession. I'm not quite sure how to.
Mr. Chairman, I have a question that might help focus
Senator
council.
Servel's
Thank
got a
you. So here's the question I have, and I haven't had a chance to compare this, but when I look at the penalties associated with unlawful sale of marijuana going forward and unlawful cultivation and all that kind of stuff, right? From my point of view, we ought to treat this identical to alcohol. And so my question is, are the penalties in here, like the Class 6 felony for an unlawful sale, different amounts, and giving it to a kid and all that kind of stuff, are all those penalties the same as the penalties that would be prescribed if an adult sold illicit alcohol, moonshine, or, for example, gave alcohol to a minor, et cetera?
And along those lines, Charles, what I was wondering, whether an individual is allowed to manufacture a certain amount of alcohol for his or her own use.
Correct.
Are the laws here with respect to manufacturing marijuana for home use consistent with those laws for alcohol?
And I'll say it might be difficult to say what's consistent or not, because I don't know how to quantify 49 plants to 100 marijuana plants to alcohol, or what's more than 100 marijuana plants to alcohol. So I don't want to say it's consistent, because the two products are inconsistent. But to the extent that it does provide for misdemeanor penalties for low-level illegal growth, a Class 1 misdemeanor, and it provides a felony penalty and obviously a more severe felony penalty. I mean, that is consistent. It's just I'm unsure how you can quantify the two of them. And I see someone from the Secretary of Public Safety's office just hopped on, so the administration might be able to offer a better idea of how they decided to come up with equating marijuana with alcohol. That is the intent, clearly. From a legal perspective, though, I don't know how you quantify 10 marijuana plants to a certain quantity of alcohol.
Well, is there someone from the administration that wants to address that?
Good morning, Mr. Chair, members of the committee. My name is Jacqueline Kachun. I'm the Assistant Secretary for Public Safety and Homeland Security. And I was part of the executive work group on this issue and have been involved in some of the bill drafts. I think the important point here is that we did try to parallel alcohol as much as possible in the code. When it comes to home growing, essentially we looked at what other states were doing and we tried to find sort of a middle ground. There is a pretty wide range of how other states punish growing more than is allowed in the personal cultivation. There's also a relatively wide range. Some states only allow up to 4 plants, whereas some states allow up to 12 plants in home grow. We went with a more conservative 2 immature and 2 mature plants. But I think the important point here is that we tried to find a middle ground on what all the other states were doing.
Okay, but you weren't trying, I mean, a person obviously can grow as much corn as they can, but they can't put it all in a jar legally under Virginia law. You weren't trying to equate the homegrown marijuana to one's ability to grow, to consume or produce homegrown alcohol.
No, sir. I think we were focused a little bit more, as Mr. Quagliato alluded to. They are very different substances, and we wanted to make sure that we were treating them appropriately. We did try to parallel the alcohol code as much as seemed appropriate, but I think here we really looked at precedent in other states and tried to find, a penalty that would make sense for the amount over the legal limit.
Mr. Chair.
Senator Morrissey.
To staff, I'm going to direct Charles or Steve to section 4.1-1100. It's line 7705 in my bill. I don't know if it's a substitute. It deals with the penalties. The substitute, I know the language hasn't changed. I want to be clear, make sure that I understand what we're doing. A person 21 years of age can possess up to an ounce of marijuana. That's clear, and that's legal. If the person possesses more than an ounce on Section B, more than an ounce, he is subject to a penalty of $25. Correct?
Yes.
Thank you.
To the extent he is not violating one of the other provisions.
I'm getting to that. Section C, if the person possesses more than 5 pounds of marijuana, then it's a class 5 felony up to 1 to 10 years and up to a fine of $250,000. Here's
Correct.
my question. Does that mean that an individual that possesses more than an ounce but up to 4.9 pounds of marijuana is subject to a penalty of $25? One word response if you can give it to me. Am I interpreting that correctly?
Looking at just this section, I would say yes.
Okay, and that's what the patrons wanted. Oh, is that right? All right. Okay. All right. Now, one final question, and I want to make sure I'm looking at line 7806 or 7799 dealing with persons 18 age of older, between 18 and 21, as well as juveniles. Did I hear Senator Serville to say that language tracks how we deal with juveniles possessing alcohol in those same age ranges? Senator Serville, did I understand you correctly?
I'm sorry, I heard you say my name, but I wasn't focused.
No worries. The language on 7799 et sec dealing with people 18 years of age up to 21 possessing marijuana, and as well as 18 years and under, you equated that in your soliloquy a few moments ago to tracking prohibitions of minors having alcohol. Am I correct that this tracks that same language prohibiting juveniles having alcohol?
Mr. Chairman, I was simply asking staff whether or not they thought it was treated identically or not. I didn't express my own opinion on it, although I would note, Senator Morrissey, that there are also provisions in 16.1 that have to do with how people under the age of 18 are dealt with, and they're treated as being delinquent as opposed to being put in a chintz petition or some other type of measure, which is something we need to talk about.
Final question then, of either to Senator Lucas or to Senator Eben. It says that any person 18 years of age or older who violates subsection A, i.e. has more than an ounce of marijuana, so between 18 and 21, that person, first offense, it's a civil penalty, but the second offense, it's a criminal penalty. Can you just articulate for me how you arrived at that determination?
Mr. Chairman?
Senator Eben.
I just want to remind you that we have folks in the administration who might be better to answer that than me.
Sure.
They developed the bill on our behalf.
And I would like a rundown from maybe those folks or whomever on how a juvenile is treated all the way around with respect to. Is there somebody from the administration that can address that?
Mr. Chairman?
Senator Lucas.
Okay, Senator Marcy, was Senator Marcy referring to the language on lines 799 through 7805?
It might be. I have the hard copy, not the substitute, but it begins with B, any person 18 years of age or older who violates subsection A.
Right, yeah,
Okay.
Mr. Chair, that's on the substitute 7806 to 7810.
Yes, I follow you now.
Substitute.
Yes, I do.
The substitute's a bound document, Senator Morrissey. Do you have it?
Yes, I do.
263 pages long, 13,000 lines. It's one of the most sleep-inducing reads I've had in a while, except for some recodification bills over the years. It's tough to get through and maintain your interest.
Okay, I'm happy. Senator Evans suggested that somebody from the administration might address that point.
Yes,
and I'm happy. If you know the order you're going in, Mr. Chair, but when we come to
if
it,
somebody from the administration, no, I'm wide open right now.
All
but
right.
If somebody from the administration wants to address that point.
Yes, Mr. Chair, members of the committee, I'm happy to speak to some of those questions. I will begin by discussing the treatment of juveniles. So if you are under the age of 18, this bill so anyone who's under the age of 18 who is found in possession of marijuana will be treated as a delinquent, not adjudicated as a delinquent, but treated as a delinquent for the limited purposes of providing the juvenile courts with the tools necessary to connect with minors with the services and support that they need, as well as appropriate deterrents like license suspensions.
excuse me, right? Let me
Yes.
just stop you right there. That's for a first offense. A juvenile under 18 who commits a second violation of subsection A is treated as a criminal offense, to wit, a class 3 misdemeanor. So a 17-year-old, 9-month, a senior, junior in high school, has a second offense, a possession of a joint, is treated as a criminal. Is that, I just want to know, is that your intention?
That is correct.
All right, Senator Lucas is saying, no, that wasn't her intention. But this law says a high school senior who is under 18, who has a second offense of a possession of a small amount of marijuana, a joint, would be convicted of a class 3 misdemeanor.
That is correct. And I would add that we, again, tried to parallel the alcohol code here. So I would say that underage use of alcohol is a misdemeanor and can result in a fine.
Mr. Chairman, we're talking about misdemeanors like they're the same thing. A class 3 misdemeanor is a penalty of a fine up to $500. If you possess alcohol, it is a class, and you're under the age of 18, it's a class 1 misdemeanor.
Right.
And you can be, if you're an adult, you can be 18 to 21, you can be incarcerated for up to 12 months. And if you're in juvenile, you could go to juvenile detention. So if we follow this approach, we're going to say if there's an unopened beer can in the back of your vehicle and you say, yeah, I knew it was there, Bob or Susie or whoever left it in my car, you could be incarcerated. But if you possess marijuana on multiple occasions, the most you can get is a fine.
You know, I agree with you, Senator McDougal. I'd like to make those penalties consistent across the board.
Isn't that right?
So Mr. Chair, I haven't heard a motion, but it sounds like the motion then would be to make any of the juvenile penalties a class 1 misdemeanor, because that is currently what it is.
I would prefer to make them all class 3 misdemeanors.
Okay.
Mr. Chairman, already it is a second offense for a juvenile who possesses a modicum of marijuana residue is a Class 3 misdemeanor. I certainly am not open to raising that to a Class 2 or a Class 1 misdemeanor. Not at all. I was going in the opposite direction, but I'm seeing language and body language from Senator Lucas that she is okay with a juvenile possessing for a second or subsequent offense, a modicum of marijuana being subjected to a Class 3 misdemeanor. It is a criminal offense, but it's only a $250 fine. All right. No, Class.
Well, Mr. Chair, it is a second offense is a Class 3 misdemeanor. A third or subsequent offense is a Class 2 misdemeanor.
Yeah.
Which is still less of a penalty than underage possession of alcohol, which is a Class 1 misdemeanor for a first offense.
All right. Mr. Chairman, I'm given the Senator Eben and Senator Lucas's acquiescence to the language. I brought the matter up. I had a discussion with some folks the other day about this. I'm not going to make any motion regarding that. If there's a consensus from the body, from the Judiciary Committee later on, then we'll take it up. Senator Lucas, Senator Eben.
Senator Morrissey, I think as long as Senator Eben and Lucas, if that is their intent, then that language is okay. My concern would be that we're punishing possession of alcohol to a greater extent.
I agree with you.
I'd like to find a way to make that consistent with marijuana. But because in my view, if there's a young person who's convicted of a second or third subsequent offense of possession of alcohol, we need to get that kid into some help, some counseling.
Absolutely.
Not jail.
Mr. Chair, I agree with you, but we're not going to correct that defalcation in this bill.
That's right.
All right, so we are the same mindset, but we'll do that with Senator Evans' legislation next year dealing with alcohol.
Get your own bill.
Mr. Chair, one penalty I know that does not, does not match up with alcohol is the penalty for using or consuming marijuana or marijuana products in a motor vehicle. It is the section 4.1-1107. It is lines 7864 to 7886. Under the current bill, under the substitute from rehab, it is a Class 1 misdemeanor. However, the possession for drinking an open container of alcohol is a Class 4 misdemeanor under 18.2, 323.1. So that is one area where there does seem to be the Class 1 misdemeanor is obviously up to a year in jail. Class 2 misdemeanor is $250 fine. I'm just bringing that to the committee's attention.
Okay. The bill as it came from rehab is this giant bill scales back the governor's ambitious approach from an effective date of January 1, 2023 to an effective date of January 2024. It takes it out of ABC and creates a new agency. Now, my sense is it's not up to our subcommittee to consider those changes. It's only up to us to look at the criminal aspects of this bill.
Mr. Chair.
Senator McClellan.
Thank you. Just to clarify that, is the delayed enactment clause for the entire bill or only for the sections of the bill that committee had jurisdiction over? And the reason I ask is it seems that it is within the purview of this committee to decide whether when we would want any of the sections of the bill dealing with the criminal code expungement or ending a prohibition, when that would take effect. Is that right?
It is.
It is, yeah.
Thank you.
Senator Eben, Senator Lucas, the effective dates of the bill right now are the whole thing is put off to January 1 of 2024, or?
There are some, Mr. Chairman, some clauses that deal with non-criminal issues with setting up the new agency that start earlier.
Yes.
And the money to do that, you think, is in the budget, or?
The governor has put in a budget proposal to transfer money for the operation of the new agency as a loan.
That is correct.
Mr. Chair, I would point out that I could be missing something. But it appears that on line 12946, the second enactment clause, that there is no delayed effective date on the repeal of certain criminal offenses. So that would take place in due course, which would be in July 1. So, because it appears as if no, I am missing something, because that except for the 4th, 5th, 6th, 10th shall become effective on July 1, 2023. I see. I was just misreading something.
Okay,
So
Charles,
the repeal would take effect on January 1,
Senator McClellan.
okay, so I'm sorry, which line was that? So if,
He's
for those
talking
playing
about the second and third enactment clauses. They're over on page 261, lines 246, 247, 248, 249. I think that's what he's talking about.
Right. So I was looking, and the second and third enactment clause, I was reading it just to make sure that the repeal wouldn't become effective, but the way it's just the way it's worded, that all the provisions of the act, except for those one specifically mentioned, will become effective January 1, 2023, which is when the repeal would take effect.
Mr. Chair.
Senator McClellan.
It seems to me, as a policy matter, we've already decriminalized simple possession. And if we know we're going down the road of legalizing, it seems to me that the repeal of simple possession at a minimum should take effect July 1 of this year, because all we're doing is setting up a situation where people are paying civil fines for something that's going to be completely legal eventually, and that, as you recall in the debate over the decrim bill, maintains, for as long as that prohibition is in place, the disproportionate impact on certain communities, particularly communities of color and poorer communities. And so I would move that at a minimum, the simple possession statute be have an enactment clause of July 1 of this year, and I think as a policy matter, we should discuss whether the entire enactment clause number 2 should take effect this year or not.
Mr. Chairman.
Senator Servell.
Thank you, Mr. Chairman. And I'm sorry I had to duck out a minute to take a quick phone call from my client, but I think that in general, Senator McClellan's heading in the right direction. However, I would point out that the second enactment clause also, I believe, repeals a whole bunch of distribution offenses, and repealing the distribution offenses without enacting a new regime for distribution of legalized marijuana creates some complexities there. But I think at a minimum, repealing 18.2, 250.1 immediately is a good idea and a laudable goal.
Well, Mr. Chair, that was my motion. I mean, my motion was to repeal, to amend the bill so that the repeal of that provision, simple possession, would take effect July 1, 2021. That's the motion. And then as commentary, I said, as a policy matter, we should discuss whether the rest is worth doing sooner or later or not. But
all right, I'll second that motion.
Got a motion and a second to make simple possession of marijuana legal effective July 1 of this year. Does everybody understand the motion? And it's been properly seconded. All in favor of that amendment, say aye.
Aye.
Opposed? Okay, the amendment passes.
Mr. Chairman.
Senator Servell.
First of all, following on that issue, though, it seems to me that that doesn't provide an answer to the juvenile situation. So what we just did, though, was we legalized it for everybody, but now we don't have any language that's in effect at the same time having to do with either under 21 possession or under 18 possession, and we would need to come up with a solution for that during that interlude.
What's your suggestion, Senator Sorrell?
First of all, I believe we would need to make the 4.1 1100 effective July 1 of this year. That's solution number one. And in addition to that, I believe at the same time we would need to make the changes in
4.1 1100. Are you talking about the whole chapter 11 or just that one section?
that one section. That one section, I believe, is the underage possession section, although it appears to have a lot of other things in it that aren't in effect yet. And so there might need to be an alternate section 4.1 1100 that's in effect for a period of time until the rest of the bill potentially kicks in.
Okay, Charles, do you understand that, what he's talking about there? Over on line 7705, wants to make it legal to possess marijuana.
Mr. Chair, I do understand. I was just trying to figure out if there might be a different way, but I do understand what he's looking to do.
Mr. Chairman.
Okay. Senator Sorrell.
Thank you. In addition to that, there would need to be some commensurate amendments to 16.1 to make those changes effective immediately as well. I believe there's some language in here repealing 250.1 and then referencing 46.2 1100. And those, for example, I think in 16.1 278.8:01 and 16.1 278.9, there's language about delinquency, and I haven't had a chance to go through all this, but there might be some other stuff that needs to get cleaned up in order to do that provisionally.
Charles, what do you think about that?
Mr. Chair, that's probably correct. I'm looking at last year what we did with the decriminalization bill and how we treated juveniles under that. And Senator Sorrell is correct that there would need to be some amendments made to the sections of 16.1, 228, 16.1, 260, 16.1, 273. And we might be able to basically put the section dealing with the juveniles in 4.1, perhaps substituting that language into a violation, into the existing marijuana possession statute to purely address juveniles, essentially repealing it for adults, but that would be a way to do it. Opposed to creating a standalone section in 4.1, which is in a regulatory scheme that doesn't quite exist yet.
Okay.
Mr. Chairman.
Senator Sorrell.
Thank you. And I know there's another policy discussion that we really need to have about whether or not we would like to continue to treat underage possession by juveniles as an actual misdemeanor versus a matter to be addressed through a Chin's petition. And I believe there's probably some public testimony about that we haven't heard yet. And so that is a sort of a separate policy discussion, which could probably take another hour. But that's also tied into all this. There's a lot of pieces of this.
Well, the reality is that we've got for me, and I apologize for this, I've got a hard end date time of 11:15. So why don't we, unless somebody's got something else they want to contribute, why don't we take some public testimony? And I understand this is a big issue. Why don't we do 10 minutes aside, 10 minutes for the bill, 10 minutes against. And then we'll spend the remainder of our time after that crafting whatever the bill we're going to, whatever shape it's going to be when it leaves here. Can we start with public testimony?
Yes, Mr. Chair. If you'd like to speak in support of the bill, please raise your hand. Mike Troxel, please go ahead.
All right. Yes, sir. Mr. Chairman of the committee, thank you very much for allowing me to speak on this. There's a couple of critical things that need to be amended. I'm a hemp farmer, and from what I can tell, this bill would lump hemp farmers in with cannabis penalties, as well as potentially criminalize folks who simply have CBD products. If we look at line 7028, you have a Class B cultivation facility license. And so that specifically relates to THC concentration of no more than 1%. That is specifically the definition of industrial hemp. And so because of that, that would lump hemp farmers into the tracking requirements for this bill. And not only would that crush the industry just from the administrative burden alone, but it would also destroy basically our business models, which is we grow our products, we then have them manufactured, and then we're able to take them to retail sales ourselves. With the licensing provision of this bill, we would be stuck only growing it, or we would have to have a retail license. But we couldn't do both unless we paid $1 million fee with this. And you know, that is just, it's just not workable. And
Sir, just first
Yes,
of all,
sir.
can you make sure you confine your comments to the criminal provisions of the bill? We also have 7 other speakers in 8.5 minutes. So today we're focused on the criminal and
Yes.
aspects. And could you
Yes,
do
sir.
maybe another
So-
30 seconds so other people can speak as well?
Yep, absolutely. So if we scroll down to the provisions regarding operating a school bus, 7901, if hemp products aren't removed from this, then a school bus driver would potentially be guilty of possessing or consuming marijuana just for taking CBD. Likewise, if we look at line 7906, no marijuana or marijuana product shall be imported, shipped, or transported into the Commonwealth. Now we're looking at banning potentially federally legal products from being shipped into the Commonwealth. Now we're looking at a federal lawsuit. And again, it's specifically avoidable if we amend line 7028. Then in line 7895, we have criminal penalties for consuming or possessing marijuana or marijuana products on public school grounds. And so are we going to slap a kid with a marijuana possession charge because they have CBD at school with them to help them focus on their classes? I mean, those are some potential issues here. And so, you know.
Okay. Thank you, sir. We need to get some other people. We appreciate those are helpful comments. Good, next.
Patrick Cushing, please go ahead.
Hey, Mr. Cushing, 8 speakers left.
Yeah, Mr. Chairman, Senator Servo, I'm on the opposed side, so I would just defer to those who are supporting at this
Okay,
point.
can we have the next speaker, please?
Kalia Harris, please go ahead.
Good morning, Senators. My name is Kalia Harris. I'm the co-executive director of Virginia Student Power Network, a statewide organization that represents hundreds of young people throughout Virginia. I'm urging you to vote yes, but with some critical considerations. Over the last 2 decades, Virginia has been convicting young people 18 to 24 for possession more than any age group. So our expungements must be full, automatic, and free for all those who are eligible and directly impacted. And resentencing hearings for those currently incarcerated should begin this year, January 1st. So I urge you to take this into consideration. Young folks are extremely impacted, and we should be treating youth as children in needs of services and not delinquents. Thank you.
Rob Pogan-Class, please go ahead.
Thank you, Mr. Chair, Senators. Legal Aid Justice Center, Rob Hogan-Class. I just wanted to speak on one specific issue. We support the broad expungement of marijuana offenses, but there is a provision in these bills that would require the payment of fines and fees before any of the offenses could be expunged, that's going to disproportionately impact people who aren't able to pay those fees. So we would suggest striking that language from lines 11,811 to 12 and 11,892 that require the payment of fines and fees before any expungements can take place. Thank you.
Tell me where those lines are again, please.
Absolutely. Lines 11811-12 and 11892. There's the petition based for felony distribution, and then there's the automatic expungement for the other offenses.
Okay, thank you. Okay, next.
Scott Miles.
Good morning, Mr. Chair, members of the subcommittee. I'm Scott Miles. I'm here representing Attorney General Mark Herring this morning. Our Attorney General supports the legalization of marijuana in the Commonwealth and supports this bill. We've reviewed the bill for provisions governing criminal penalties and also handling of juveniles, and we're grateful to the patron for his willingness to include us in discussions about these provisions. Thank you.
Okay, thank you. Who's next?
Eileen, please go ahead.
Yes, thank you, Mr. Chair. Eileen Longenecker with OES at the Supreme Court. We have no position on the policy of the bill. What I'd really like to just quickly address is the automatic expungement. It's not entirely clear. The automatic expungement statute seems to include both an automatic piece and a manual piece. It's not entirely clear. We did discuss this with Secretary Moran and raise this issue. If, as we read it, it's an automatic piece and a manual piece, we cannot do the automatic expungement piece by July 1, 2021. As was discussed previously with the expungement bills, for example, Senator Lucas's bill, Senator Morrissey's bill are automatic expungement and have a delayed effective date of July 1, 2025. There are significant changes to the IT systems that must occur in order for this to be electronically communicated, which is required for the automatic expungement. And we understand that the July 1, 2025 date was in part driven by Virginia State Police's ability to implement the programming changes for automatic expungement. And we cannot implement those changes to do the automatic expungement until we are able to communicate with state police and make those changes happen in conjunction with state police. And so for the automatic expungement, we will not be able to do a July 1, 2025 date. We also noted some other implementation questions. We raised those with Secretary Moran and his staff, and we appreciate the time that he and his staff gave us to talk about some of these issues. But I think those need to be addressed. Lastly, I would just add that the automatic expungement piece is IT changes, significant IT changes. The petition-based process is significant clerk time, and both of those would need resources. We can do the petition-based changes July 1, 2021, but not the automatic. That would need to be farther out.
Gotcha. Thank you very much. We've got a bunch of people left. Who's next?
Tom Antorchio. Please unmute yourself.
Yes, thank you, Mr. Chairman and members of the subcommittee. My name is Tom Antorchio. I'm an associate director with the Virginia Catholic Conference. We oppose this bill.
Hold on a second, because we're trying to finish up with the people that are for. The people that are against are going to get their 10 minutes. Okay, you're in the next block.
Thank you, sir. Appreciate it.
Yes, sir. Okay, who else is for the bill?
Please only raise your hand if you'd like to speak in support of the bill. I believe Vicki Williams. Please go ahead.
Good morning. Thank you so much. I'm Vicki Williams. I represent Decriminalized Virginia, strong proponent of the restoration of rights. I support the legalization of cannabis, certainly support the automatic expungement provision in the law. I urge legislators to remove the fee as well as remove the section that stipulates that all fines need to be paid. I appreciate Senator Lucas. I appreciate Senator Morrissey. I appreciate Senator Evan, and I appreciate the body. Thank you so much.
Thank you very much. Who's next?
Alan Denikis.
I'm speaking in opposition. I'll wait.
Okay.
Kimberly Hartka. Kimberly Hartka.
I'm also speaking in opposition, so I'll wait.
Melanie Davis.
Good morning, Mr. Chairman and committee members. I'm sorry, I'm at work. I'm an ER nurse, so I can't do much about that. My name is Melanie. I'm an Army brat, a JMU grad, a 17-year ER nurse, and a 27-year Virginia resident, married to a lifelong Virginia resident. Most importantly, I'm Aiden and Madison's mom. Madison is my youngest, my best friend, and the joy of my life. She learned to read when she was 4, and shortly after she turned 5, she was diagnosed with a rare form of brain cancer called ependymoma. She spent the next 2,280 days fighting one of the nastiest beasts there is. In total, she fought 14 brain and spine tumors with every treatment and trial you can imagine, here and at home, and all over the country. Endless months of chemo and radiation, 13 surgeries, and over 250 sticks with a needle. My world lost its brightest light on May 11th, 2020, when just after her 11th birthday, she died at home in our arms. Cannabis was a huge and essential part of why she was still here and still herself 6 years into the battle for her life. Why she only ever had 3 seizures, while she never had any of the toxic nausea and vomiting side effects of her chemo, and why she did not have to spend her days in an opioid-induced haze as her central nervous systems fought to keep giving her the urge to breathe. Maddie lived because of the 4 different cannabis products she took for 1,460 days at the astronomical cost of $100 a day. We were not able to save Maddie's life, but I'm committed to seeing changes to the laws that limited my ability to ease her pain, laws that cost our family $100 every day for cannabis medicine that had to be obtained on faith and from strangers, uncertified, untested, unreliable, and unsustainably expensive. I am truly and deeply grateful for the changes that have taken place in Virginia, and Madison was a very early patient in Virginia's medical program. However, at the end of the day, for my sweet girl, it was not enough for many reasons. One big reason that you can help solve today is that the current law did not allow her to obtain medicine in doses even remotely close to those recommended by licensed cannabis providers and necessitated by her disease, its treatment in her body. My girl took 300 milligrams of THC every day for 4 years. That means she would need her entire monthly allotment of THC before the bedtime on the first day of that month. If the bills before you this year were law when my sweet girl was still alive, we could have purchased usable cannabis from a licensed and regulated distributor, or even better, we could have grown 2 of our own plants at home, and we could have treated Madison with natural and effective medicinal oils made in the safety of our home with ingredients we supplied at a small fraction of the cost.
Thank you so much. I'm so sorry.
If you're interested in more of Maddie's story, there's a wonderful documentary called Little Bit Fierce about the bravest and kindest girl I've ever known. When you know better, you do better. Right now, in this legislative session, now is the time to do better. The time for common sense changes to our cannabis laws that include allowing personal cultivation and for the sale of more than just oils and gummies. Not in July, and certainly not in 2023, but now, when it's not your child, and it's not only pediatric cancer warriors that benefit from cannabis. When better laws may not directly help or affect you, but could dramatically change the lives of countless Virginians in near unimaginable ways.
Thank you very much.
You don't have to wait for another confession from a parent desperate to give their baby a life worth living. Please stand on the right.
Jen Michelle Padini.
Okay, we're out of time, so just tell me your name, and if you're associated with the group, I want to know what the group is, and then I want you to tell me you're for the bill or against the bill.
Thank you, Mr. Chair. Jen Michelle Padini on behalf of the National Organization for the Reform of Marijuana Laws. We support the bill and have provided direct feedback to committee members and patrons.
Thank you so much. Who's next?
Our final speaker is Marty Jewell.
Good morning, ladies and gentlemen. Marty Jewell with Cannabis Equity Coalition of Virginia. We support the bill.
Okay, thank you so much, Marty. Okay, now we've got some people that have another point of view. So if you're, I want to hear from the people that are against the bill now, and you have 10 minutes total, and I'd appreciate it if you respect other people's time.
Patrick Cushing, you're our first speaker, and just a reminder, if you'd like to speak in opposition to the bill, please raise your hand.
Thank you, Mr. Chairman, members of the subcommittee. Patrick Cushing on behalf of AAA, and we oppose the bill. That said, I do have some recommendations on how to strengthen the provisions related to impaired driving. And there was a discussion on that earlier. I do want to thank the patron and the administration for including the open container provision that we have in our law concerning alcohol. On page 159, you'll find section 4.1-1107, which is the open container provision. Our recommendations were emailed to the committee, but they are all contained within subsection C. The open container provision is not an exact parallel to our alcohol provision. Specifically in subsection C, what this provision does is creates a permissive inference that there is consumption if you meet certain criteria. The alcohol law creates a rebuttable presumption, which is stronger than the permissive inference.
Mr.
So
Chairman.
we recommend.
Senator Servel's got something.
Yeah, can I just say really quick, Mr. Cushing, that language was put in at my request because this Court of Appeals of Virginia has found that it is unconstitutional to use rebuttable presumptions in criminal statutes, but for some reason we've never updated our code. They have said permissive inferences are constitutional, and that's why it's in there. I just thought you might want to know that.
Got it. No, that's good. And the stronger preference is if ruled unconstitutional, then obviously you'd have to go with the permissive inference. So I would retract that amendment. But then going down to the factors that contribute to whether that permissive inference can be made, odor was taken out of this provision. It's something that exists in the alcohol provision, and we would recommend inserting odor back into the list of elements that can be used to make that permissive inference that somebody has consumed in a motor vehicle. So that's our primary recommendation, and we appreciate the committee's consideration of that recommendation.
Thank you so much. Who's next?
Tom Intortio and Alan Denikis, you're our next speaker.
Thank you, Mr. Chair, members. My name is Tom Intortio. I'm an associate director with the Virginia Catholic Conference. We oppose this bill, and I will just defer the rest of my time to those who are going to speak after me. Thank you.
Thank you so much. Who's next?
Alan, please go ahead.
Thank you. I'm speaking, thank you for the opportunity to speak. I'm speaking as an emergency physician with 30 years experience, and I'd like to oppose the non-medical uses of marijuana in Senate Bill 1406 and related bills. You all are working so hard to eliminate poverty, homelessness, domestic use and violence. We want to see our children well taken care of, and we want to see drug dealers and cartels and gang activities off the streets. And and we also want to keep our medical costs down. So why in the world are we passing legislation that is going to increase all of the things that we're trying to get rid of? There is a threefold increase in use of marijuana following legalization. There are also medical effects. A person has a 4 times increased risk of heart attack during intoxication. There's an increased long-term risk of vascular disease, heart attack, and stroke with chronic use, respiratory problems, including asthma, COPD, respiratory infections, cyclic vomiting syndrome, impaired cognition, coordination, and complex decision-making, leading to increased motor vehicle trauma, and as our AAA friend talked about. And this takes up ER and hospital beds at a time when we're trying to fight COVID. It's also a risk to children because drug users often leave paraphernalia and marijuana-laced brownies and confections around for kids to get a hold of, and that results in pediatric hospitalizations. It has psychiatric effects, which are much more dangerous than alcohol, as well as the physiologic effects. Schizophrenia, psychosis, which leads to crimes, even murder. Depression, suicide, memory and cognitive impairment, decreased school performance, and developmental delays, and then not to mention the expense and the political infrastructure that is being put in place at a cost of $8 to $20 billion just in regulatory costs to Virginia taxpayers. So for all these reasons, I strongly urge you to oppose the non-medical uses of marijuana. Thank you.
Thank you very much. Who's next?
Kimberly Hartka and Will Jones, you'll be after.
Hi there. I represent parents opposed to pot. We are strongly opposed to the legalization of marijuana. Parenting and pot use is totally incompatible. We have tracked 250 innocent child deaths just since the voters in Colorado legalized marijuana. The effects of marijuana are mind-altering. They are impairing. I think I should draw to your attention that it's very impractical to tell parents they can raise 4 plants in their home, but they have to keep it away from young children. There's no reason to think that they'll be able to do that. You can't grow it in a locked box. It needs sunshine, it needs water, it needs care. It's going to be accessible to children. There's other issues with home grows. Landlords are going to have to remediate their properties after a tenant leaves that's been growing or using in the home. Drywall has to be replaced because the stench permeates the walls. Also, home grows attract crime. They attract home break-ins, and there's even been murders of home growers. So I do strongly urge you to reconsider the whole home grow issue, and also the aspect of, do we really want the age range 18 to 25, the most likely to increase use when they're young parents using this drug? Thank you very much.
Thank you, ma'am. Who's next?
Will Jones, please go ahead.
Mr. Jones, are you out there? Mr. Jones, are you out there? Going once, going twice. Who's next after Mr. Jones?
Philip Thompson.
Thank you. This is Philip Thompson, Diverse Engagement. My opposition to the bill deals more with what the bill doesn't allow, and that's, more freedom and less restriction on marijuana possession, use, and sale. I can go out and take my pickup truck and buy, a full pickup truck full of beer and, have no issues there. But, if I got, more than 2 plants or in my house, then that's a problem. And I think that, the more restrictions we're going to have on marijuana possession and use, is just going to wind up with more African Americans being pounded by the criminal justice system. So I like legalization of the bill, but I don't think this bill goes far enough. And I think, it's the typical Virginia way of trying to do something halfway instead of doing it all the way and allowing people to express their personal freedom. Thank you.
Okay, thank you. Thank you very much. Who's next?
And our final speaker, Regina Whitsett.
Good morning. I'm Regina Whitsett. I'm the Executive Director of SAFE. We're a Substance Abuse Prevention Coalition in Chesterfield County, and we oppose Senate Bill 1406. I asked this body, why are we turning over Virginia to big marijuana? We just decriminalized simple possession 6 months ago, and we're already having adverse effects on our roadways from that decision. Also, the Board of Pharmacy in Virginia has been working to set up CBD, THC, low THC oils in Virginia since 2017, so patients can have pharmacist approved products, and marijuana legalization will make high potency THC products available to Virginia citizens. And these could possibly have drug interactions with the pharmaceutical medicines that people may be taking. Also, there is an opioid epidemic going on in Virginia. In Chesterfield County last weekend, we had 6 overdoses in 72 hours. First responders are already strained from this crisis, and marijuana legalization will only create more poisonings by children, more psychiatric episodes, and more car crashes, which will further exhaust our first responders. Finally, I'm shocked that in the middle of a pandemic, when our hospital ERs are overloaded, that you are even considering this legalization. It is not time to legalize another drug that will put further burdens on our healthcare workers. Please don't sell out Virginia to the marijuana industry. They are the next big tobacco, and we oppose this bill.
Okay,
thank you.
ma'am. Mr. Jones is back. Will Jones, you've got a minute.
I appreciate that. Can you hear me now? The audio wasn't. Okay, thank you. I represent Smart Approaches to Marijuana based in Alexandria, Virginia. I myself am also a full-time firefighter and EMT, and we oppose this legislation. We applaud the desire to see the reduction of arrest and incarceration, particularly people of color, and we support things that Virginia has done. For example, the decriminalization bill that was passed, but we have major concerns about the implications of legalization and what has happened in other states that have gone down that road. We have seen actually an increase in overall arrests of African Americans, particularly of youth, in states that have legalized. This is available to see in data and written testimony provided that in fact overall arrests of African Americans has not decreased since legalization. And I just refer to alcohol. There are nationally, because it's legal, in the effects of alcohol, particularly when you use under the influence, there are millions of arrests, over 2 million related alcohol arrests, whereas that's 800,000 for marijuana. If we see marijuana legalized, as it is in Colorado and other places where there are more pot shops and Starbucks and McDonald's combined, related arrests in state after state, including California, Illinois, Michigan, we've seen overall arrests of African Americans actually increase and not decrease. And so for that reason, many others that cannot fit in this time frame, we strongly oppose the legalization for recreational use. While we do support decriminalization and expungements, but we oppose the commercialization and legalization of marijuana.
Okay, thank you very much. Is that the last speaker? Okay, we've got about 23 minutes to figure out what we're going to do with this bill, and it's before you, and I would appreciate any comments or suggestions that you might have.
Mr. Chairman.
Senator Servo.
First of all, I have one question for, I guess, Mr. Qualiato that some of us were talking about in the back a minute ago. Charles, last session I carried legislation which adopted some provisions that related to the USDA definition of hemp, and I can't remember whether my bill only had to do with testing to make sure we're using the right test to differentiate between hemp and marijuana, or whether my bill extended to the actual definition of marijuana versus hemp. But we heard some comments at the beginning, right, when our chairman left the room for a minute, from a hemp farmer who felt like a lot of hemp farmers were being caught up in this, or people were being caught up for possessing CBD. Is that distinction covered in this bill?
Mr. Chairman?
Mr. Chair, quite frankly, I don't know. I can certainly look into it, and I think the committee's preference would be to make the clear distinction between hemp and marijuana.
Yeah, Mr. Chairman, I think the gentleman's comments, the witness, were unfounded, and I'd like to ask Brad Copenhaver, Deputy Secretary of Agriculture, could address that.
Is Mr. Copenhaver still on the line?
Madam Clerk?
Yes, Mr. Chair.
I don't think she heard you, Cree.
Brad Copenhaver, are you still on the line? Okay, thanks.
Further, Mr. Chair, while you're waiting, I provided the committee members with the side-by-side with the issues that I thought were most illuminating, with comments from various groups that you may have a side-by-side that might be helpful. I don't know.
It most definitely would be helpful, Mr. Senator Abbott. If you've got the side-by-side you want.
You have one at your desk. I'll give you one.
Yep. Okay. So we don't have Copenhaver, Mr. Chairman? Okay. All right. Well, Mr. Chairman, I guess we can't get input or clarity on that right now. I'll take Senator Evans' word for it for the time being. But Mr. Chairman, you know, when I look at this bill, just this side-by-side we got, there are, it appears to me, about 7 or 8 different areas on this chart alone, and probably more that I could think of things that we need to talk about in exquisite detail that I think we could probably spend at least 30 minutes a piece on, maybe as much as an hour. There is a lot in here, and I have a hard time seeing us reach resolution of that stuff unless we sort of figure out what we want, if we want to prioritize anything, or whether we just want to send
Servo, if you want to come back here tomorrow afternoon after the session, and we can continue the subcommittee until then.
Well, there's a lot to talk about. It's not clear to me. We're not going to get it done today. That much is clear to me, and there's a lot to do here. That's all I can say. I'm kind of overwhelmed trying to figure out how to create a plan to work through it.
There's an awful lot here. You know, what I can suggest, and I went through this bill night before last, and as I said, it was a glassy-eyed experience. You know, after a while, the words were running together, and this is my 30th session. I've not seen a bill like this except for recodification of titles. I've not seen a bill this long. So I want everybody in here to be comfortable with whatever we do, and so I would suggest we either figure it out in the next 15 minutes, we think about it overnight and meet again tomorrow after the session, or we make a motion.
Motion. Mr. Chairman, I move the bill pass. I move that you recommend the passage of the bill.
Mr. Chairman, so
Senator Lucas, you're not on this.
no, she's not on the committee. Yeah. It's Mr. Motion. I'm not sure Senator McDougal's motion was serious. I suspect it wasn't, but I think in order, if we really want to work on this, I think we need to sort of go offline and try and figure out exactly how to focus a work plan to get through it, if that's the objective, because there's a lot to get to here. I mean, so that's my suggestion, is that we adjourn right now. We figure out if we can do anything. If we can go through this, we need to prioritize it. If we decide we can't do that, we still come back tomorrow and tell the public, what we're doing. I think that's probably the best thing to do.
Would it be all right for us to meet tomorrow after session? Would we be able to find some time to do that?
I think so.
Okay.
Mr. Chair.
Senator Morrissey.
With Senator Servo, we can pass this bill now, or we can pass, hopefully, and perhaps a stronger bill after debate tomorrow. So I think let's try to get it we're not going to get it perfect. And there's going to be, this is a work in progress, but let's do the best that we can. And I agree. Let's come back tomorrow either early in the morning or right after session.
Well, I'm afraid there are too many early morning meetings on the schedule, so it's probably going to have to be after session.
Yes, sir.
Mr. Chairman.
Senator Stanley?
Yeah, and if I just may opine, there are only a couple of us over here on the other side of the aisle, but, when we see bills this giant, this big, and I wasn't there on recodification, but we've had some doozies that were not close to this. But my experience has been, I think everybody's experience has been in the subcommittee and in the Senate, is that when you've got big bills like this, you've got big issues and potentially big errors. And this is one of the most important policy changes that we're contemplating in the Commonwealth of Virginia. We're taking something that has now just been decriminalized, and we're not only legalizing it, we're creating a new industry. And with that, new regulations and new laws.
And a new regulatory board.
Right. Exactly, Mr. Chairman, you're exactly right. And my problem is that when we try to rush something through, those big errors become big problems later for the people that are then involved in this industry or whatever we do. So, even though, and I must admit, our side wanted to limit this session to 30 days, perhaps it wasn't a good idea in contemplation of this massive bill. And I think, we've got 15 extra days coming up in special session. If we carefully go through this, I think we can put it in its best posture in terms of expungement and the things that we're tasked with as a part of this, and allow all of us to contemplate and think about this, not try to rush something through tomorrow morning. And with all due respect, Mr. Chairman, I love the junior senator from the city of Richmond with all my heart. We've been friends for 20 years. But I don't think everything, when we say, it'll never get it right, it'll never be perfect, I think this is too big and too important, Mr. Chairman, to get it wrong, for speed's sake.
Your preference would be not to worry about tomorrow, but wait till after the governor calls a special session.
Mr. Chairman, and if I remember correctly, at least in the rules that Scotty put together for that special, these bills can be carried over into that, where we then have more focus, where we're not thinking, Mr. Chairman, about crossover coming up so quickly, and we have to do this, and we can actually use that time, that 15 days, to really dive deep into this thing, because I'm not through it all the way, and I'm like you, Mr. Chairman. And I'm a lawyer, and I read the code all the time, like you do, Mr. Chairman. And I'm just, confused. I feel like I'm in a forest with no sunlight and trees.
That's the experience I had, but the whole idea behind the special session was so that we could have the normal 46-day session. I don't know that we're going to be able to carry this over past. I want to get something done by tomorrow. I want to be able to make a report to the full committee on Monday. So as much as I'd like to go to my office and practice law tomorrow afternoon, I think this is important enough that we ought to be able to schedule some time after the session tomorrow to come back and work this up. And we ought to bring an extra sandwich and plan on just working it as hard as we can. And if we can't get anything done, we can't get it done.
Mr. Chairman.
Senator Servo.
And I appreciate all. That's why I think we need to refine this in discussion, probably offline before we come back tomorrow. But I would also just note for the body, we have a really small docket in the full judiciary meeting on Monday, doing little things like qualified immunity, medical malpractice cap, expungement. Right. We're going to have plenty of time on Monday morning to get all those things done, along with marijuana legalization. And of course, nobody else in the committee has any opinions about this, so they're going to do exactly what we say.
Senator Eben.
I just wanted to point out the Deputy Secretary of Agriculture, Brett Copenhaver, is available now.
He is available to address the issue we had a member of the public expressed concern that hemp growers were getting caught up in some of the new regulations. And there was some question that Senator Eben thought you could address.
In CBD, Mr. Chairman, his concern was that under section 4.1, 1110, 1111, and 1112, that somebody, I think, that was using CBD could get caught up in that for using a marijuana product while operating a school bus or by going to a classroom or something.
And Mr. Chairman, this is Senator Stanley, and I think the hemp growers and one that testified is concerned about the licensing and the suspension and the fine of $25,000, and whether they fall into that definition under in lines starting 7416 through 7430, and those are significant.
They are significant.
Mr.
Mr.
Chairman,
Copenhaver, what say you?
Mr. Chairman, thank you for the opportunity. Hemp and marijuana are kept very much separate. In Virginia, industrial hemp is cannabis with less than 0.3% THC, and that is the federal definition. I believe what Mr. Troxel may be referencing is some updated rules that just came out of USDA a couple of weeks ago that raised the criminal negligence threshold and the threshold for which the Department of Agriculture may require a hemp crop to be destroyed to 1%, but that does not mean that anything above 0.3% can be sold into commerce. And so we tried we are keeping the hemp products and the hemp program separate from marijuana. According to our definitions, anything that is over 0.3% THC must be considered marijuana because according to federal law, it cannot be considered industrial hemp. So if someone has a CBD product in their possession that is a hemp-derived CBD product, by definition, that contains less than 0.3% THC and is a hemp product. So that would not fall under what we're doing here.
So ultimately, that you underline the main problem we've got, and that's that whatever we do, we're going to be doing something inconsistent with federal law.
Right. That's correct, Senator, and we set up provisions in this bill to deal with that. The primary one being that we have a track and trace requirement, regulatory requirement, where we ensure that no products would be crossing state lines or being sold into the illicit market, and that's really what the federal government cares about. As long as it's all contained within Virginia, referencing the 2013 Cole memo from the Obama administration. And what we expect the Biden administration to do as well. Those are the parameters that states have been operating a legal adult use market.
Okay, does anybody have any questions of Mr. Copenhaver?
I do, Mr. Chairman.
Senator Stanley.
Thank you. Sir, if this doesn't apply, this statute or this bill we're looking at and the licensing requirements and the suspension of the licensing, then why the under 1% standard for a Class B licensure?
That's a great Mr. Chairman, that's a great question, Senator Stanley. What we have heard from some hemp farmers is that it is very hard sometimes if you're growing certain strains for certain products like CBD products. It is difficult to keep a crop under 1% THC. And so what we decided to do was offer an alternative to those farmers who, rather than registering with VDAC, they would register with the cannabis regulator to grow what's called low THC cannabis, or Class B license, that could be up to 1%, that they could then sell into the regulated marijuana market, giving those farmers the option of whether they want to register with VDAC and sell or grow and sell industrial hemp, or they want to register with the cannabis regulator and grow low THC cannabis, which we would have to consider marijuana, but it does provide some flexibility for farmers to make that decision.
Mr. Chairman.
Senator Stanley.
And I see that, and that's line 7028 on that with the Class B cultivators. But there's just no exemption in the licensing plan for the 0.3 standard that you're enunciating. Wouldn't you agree with me? I mean, there's a distinction right there in 7028. Beginning.
I agree, Senator, but the distinction is in our industrial hemp law, in that to grow something that's considered industrial hemp, you must be registered pursuant to the hemp code with the Virginia Department of Agriculture and Consumer Services. If you're growing something else, you like if you're growing this low THC cannabis, you would need to be registered with the other department. So it's all in the definition of the products and where you're registered to grow the crop.
Thank you, Mr. Chairman.
Okay, and unless there's anything else right now, we're going to adjourn until tomorrow. At the adjournment of the Senate, we're going to be back in this room. And my plan is to try to see if we can get something out tomorrow afternoon. To Senator Servel's point, I don't know that he's here anymore. Okay, we ought to have a discussion, and so we can kind of outline the issues we need to address between now and then. We need to figure that out and have an agreement. Hopefully we can all come to an agreement on what sort of outline we need to have in place to figure this out. Senator Morrison.
I know Senator McClellan and I have rescheduled Richmond judicial vetting 3 times to sometime tomorrow afternoon. I'm committed all afternoon into the evening to do what we have to do, but I want to be a part of this discussion, but I do not want to miss Richmond judicial vetting.
I get it. I get it.
So
everybody's got things.
I'm going to talk to her and tell her that we're going to meet tomorrow afternoon after session. It's just a matter of when.
Okay.
Maybe we'll be moving. Maybe we'll meet at 10 o'clock to the session tomorrow.
Okay, well then with that said, we will rise until tomorrow afternoon. Thanks.